call the bond forfeitures.
State of Ohio wishes to keep W now. Case number CRB 21-288, TRC 21-121, A and B.
All right, this is Mr. Soward's bond. What's the status of this, Mr. Soward?
Your Honor, I've been in contact with Mr. Cooper, and he had asked me to give him more time. He works out of town for a flooring company, and so he asked for permission to go to Miami to do a flooring job, and I told him, I said, I can't really give you that permission, but you can call your lawyer. Anyway, I did finally tell him, I said, well, I would at the very least suggest you get a letter from your employer and go make a payment. So I believe that should be in his file. And I think a $100 payment was made. He did call me last night and said that the job they're doing is taking an extra day. And he says he'll be here on Monday with a $400 to $500 payment. So.
He made a payment on July 5th of $100. There's a note, a handwritten note in the file that is undated and not on any kind of letterhead. So I mean, you know, I'm going to leave the warrant outstanding, and he just needs to come in when he gets back.
Yeah, I think Monday he'll be here.
He had more time on the bond, so let's set it for another bond forfeiture hearing about August the 4th. Are you in town then?
Yes.
All right. I'll give you a continuance on the bond forfeiture to August 4th will be the next bond forfeiture hearing, 10 o'clock. The warrant will remain in effect.
Okay.
State of Ohio versus Joseph Atkins, case number CRA 23-260, CRB 23-261, TRD 18-2412.
Okay, also Mr. Soward's bond, Mr. Atkins had failed to appear July 3rd.
Your Honor, he has been fired from his employer and has moved from the address that I have on file. So the chase is on, and I have a good idea of the vicinity that he's in, and I've been surveilling that area. I don't think it's going to be too difficult for me to find him.
Okay, I'll continue this, give you some more time to round him up. I'll set the bond forfeiture for August 4th also on this case. Warrant will remain outstanding.
Got one more. State of Ohio versus Kyle Akers, case number CRA 23-378.
Your Honor, Mr. Akers is in the Boyd County Detention Center. He has a felony hold on him from his parole officer in Kentucky. The Lawrence County Sheriff's Office has contacted the Boyd County Detention Center and placed a detainer on him as well for us. So we will get him back as soon as he satisfies his parole officer in Kentucky.
Okay, do you have any idea when that's going to happen?
I have no idea. I don't know what his situation is with Kentucky.
All right, we'll just continue this one to August 4th. Also, bond will remain, or the warrant will remain in effect.
Thank you, Your Honor.
You're welcome. Okay, that finishes the bond forfeiture hearings. So next we're going to do reviews for people who have been ordered to accomplish something by the court. We'll check to see what progress is being made. So when your name's called for review, come up to the table to the right, stand there, and we'll go over your file.
Tia Hammond, Danielle Summers, Christopher Blake, Michael Easterling, Elizabeth Hoffman Howard.
All right, Tia Hammond, 13538. She's She's at RRG. Got a report from them.
She's doing well. She didn't notice that she signed up once we got her into the event. She signed up with ODP at first, and I told her that she was supposed to be with us. She immediately switched it. She's done really good with us. She got a job at Wendy's. I think she starts today at 1. I've got to take her right after this to go back so she can get ready for work. But she's doing really well.
And that's your first day, or
Yeah.
you've already been working there?
Today's my first day.
Okay, all right, well, we'll wait on payment on you. You've got fines to pay too, so we can wait till you get more on your feet.
Thank you.
I'll set your next hearing for August 21st, 9 o'clock.
Your Honor, if you need me today, just text me.
Okay.
I've got to be in the field.
All right,
Thank you.
thank you. Danielle Summers is here. She's at RRS. Good drug screens and compliant with their sessions, so very good. You have a payment on your phone?
Yeah, I paid 50 last week, I'm paying 20 today.
Okay. Okay, I'll set August the 18th as your next hearing.
Thank you.
9 o'clock. You're welcome. Christopher Blake. 23,440 and 18,357. He's done some community services last time he was here. You still have a couple days left to do, is what I'm saying.
How many days of community service do I have, Your Honor?
You had 5 total.
Oh, I have 5, okay.
I'm showing you've done 3. Is that right?
I've done 2.
All right, well, we need to get that done. Do you have a payment on your fines today?
Yes, Your Honor.
How much you paying?
80.
All right, see the clerk, make that payment, and I'll set you for August the 18th also.
18?
Yes, sir.
Okay.
9 o'clock.
Thank you, Your Honor.
You're welcome. Michael Easterling, 22,785. Okay, you just have, I don't see anything's been done. Have you done anything on your case so far?
No, I had just got done with Ironton's down there.
Okay.
I need to know if I can work community service down there.
You can do community service. Where do you want to do it? Ironton?
Yeah,
You can do it at the Ironton Municipal Court. And just make sure they know to send it up here for your credit.
Okay.
You still living in Colgrove?
Yep.
Okay, do you have a payment on your fines today?
no, I will have Thursday.
Okay, you can work extra community service
Yeah.
on your fines.
I'll probably do that too.
Okay, I'm gonna set your next hearing for August 14th. And let's get something done in the next month. 9 o'clock, August 14th. Elizabeth Huffman Howard's been called, has not appeared, which is kind of disappointing. She was doing well. Bench warrant 7 days.
Sabrina Pettiford, Christopher Reed, Anthony Taylor, Tiffany West, and Donald Porter.
Sabrina Pettiford. 22,104 and 02,214. Okay, your community service is done.
Yeah.
You've got still fines to pay. You have a payment today.
$60.
Okay. Cedar Park, make your payment. August 14th will be your next hearing.
Thank you.
You're welcome. 9 o'clock, August 14th. Christopher Reed.
Yes, sir.
0257. Okay. All you got left is a day of community service, is what I'm showing. Is that right?
Yes, sir.
When can you get that done?
It'll probably be a month. I'll split my meniscus and my knee.
All right, I'll set your next hearing for August 28th. I'll give you about 6 weeks to get it done. Get that done, you don't have to come back.
Yes, sir. Appreciate you.
You're welcome. Anthony Taylor.
Here. Blue Jeans Judge.
All right.
He is in Montana this morning working. I turned in, he emailed some community service hours, 40 in total. I gave those to Mr. Major, who's going to provide those to Josh.
Okay.
To
His pay
confirm-
is fine. What I'm showing you is he owes the community service, and I don't have anything showing he did the dip school either.
That, I don't know. Anthony or Keith, have you done the dip school?
No, sir, it was canceled in our area.
He still needs to do that. I know he sent the
You can
community
go to
service.
one in Scioto County, you can go to any one that's approved by the state of Ohio, but there is not one currently in Lawrence County.
Right.
Yes, sir, I'll do it when I get back in town,
When is that? When are you coming back in town?
October 16th.
No. I'll set your next hearing. You can do it by teleconference, but if you still have, well, I'll go ahead and go beyond the 16th of October. Let's make it October 20th. October 20th will be your next review hearing. So you've paid all your fine.
Thank you,
October
Judge.
20th, 9 o'clock.
See you, Keith.
Thank you.
Tiffany West,
Here.
23146. And we're at Fresh Start Health International, still there? Do you have any kind of report from them?
No, not today. I didn't know I needed to bring one.
And you've done,
I've got 1 day of community service left.
you've got 4 days done.
Yes,
Do you have a payment on your fines?
I do. I've got 40.
Okay. Make your payment. I'll set you for August 28th. If you get everything done by then, you don't have to come back.
Okay.
August 28th, 9 o'clock. Donald Porter. Yes, sir. Got a report from Mindy Reeves. And I think you've done all available community service that you can do, it looks like. Do you have any payment on your phone?
I have $20 cash.
Okay. All right, make that payment, and I'll set August the 14th for your next hearing at 9 o'clock.
Thank you.
That finishes the reviews. We're going to start the arraignments now. So anyone that's out in the hall that has an arraignment, a new case or a missing hearing on an old case, you need to come into the courtroom.
You have an arraignment, you need to be in the courtroom now.
All defendants, and we'll explain your rights, and I'll do it more than once if you want, but we try it as a group, and then if you have questions, we'll go over individually with you. All defendants have the right to remain silent. You're not required to say anything in court, but what you do say is all being recorded, it's on the record, so that means if you get up and admit something that's damaging to your case, the prosecutor can use it against you in the prosecution of your case. So You have a right to have an attorney, and if you're facing a jailable offense and qualify financially, you have a right to have an attorney appointed to represent you. You have a right to bail, to make the state prove any charges beyond a reasonable doubt. You waive those rights if you enter a guilty or no contest plea. So if I ask you for a plea, the safest plea you can enter is not guilty. That preserves those rights. And you should not enter no contest or guilty just to get it over with. If you want to talk to a lawyer, if you want a trial on your case, definitely you need to enter a not guilty plea. Or if you don't know what to do, you need to enter a not guilty plea. Call the first case.
State of Ohio versus Christy Pruitt, case number CRB 21688.
And you have an attorney, ma'am?
Jim Pierce is
All
here.
right, Mr. Pierce.
He's on his way. Wants to come by you.
All right, Mr. Pierce, are you entering an appearance for Ms. Pruitt
Yes, Your Honor.
and enter a not guilty plea?
Not guilty, Your Honor.
You waive a reading of the charges?
Yes.
Any objection to no R bond?
No, Your Honor.
Okay. Ms. Pruitt can sign a signature bond, which means you're just guaranteeing your own appearance.
Okay.
As long as you show up, you don't have to post any money. If you fail to appear, you get a warrant, and then you have to pay $1,000 for non-appearance.
Yes, sir.
Okay, this is an older case. It's a 21 case number.
Yes.
Is this going to go forward there? Do you have any idea?
We'll contact the alleged victim and find out where we
Okay.
stand.
Any preferences as to, we need to build in a little lead time then for that to happen before we come back for a pretrial, I take it?
I think it would be advantageous to both sides. Yes.
Maybe 3 weeks or so, something like that?
Will that 3 weeks work for you?
That's fine.
Yes, sir.
Okay, that's August 4th. That's the first Friday in August. Is that date available for you, Mr. Pierce?
I can make it start with me.
Okay.
Really miss work down there.
August the 4th at 10 a.m. will be a pretrial. Not guilty plea is entered for Ms. Pruitt. Any questions?
No, sir.
Just one, Your Honor. Back in 2021, when this originally was set for an arraignment, Ms. Pruitt was out in Oklahoma. Didn't expect it, didn't know what to do with it, didn't even hear about it until she returned home.
Okay.
So there was an actual warrant for today issued.
The warrant
But I
will be-
said we're going to make a voluntary appearance.
I'm withdrawing the warrant. The warrant's withdrawn.
I'd love to ask the clerk of courts for something to that effect so she can have it on her person just in case.
She can see the clerk and get something to show
Thank you,
that
Your Honor.
the warrant was withdrawn.
Thank you, sir.
Thank you, sir.
Okay. I will try and see what I... State of Ohio versus Kevin Montgomery, case number TRC 23. $23,937.
All right, sir, are you Gavin Montgomery?
Yes, sir.
Mr. Montgomery, it's alleged that on July the 8th at 2:21 a.m. in Fayette Township, you were driving a vehicle while you were under the influence of alcohol. State's alleging that you took a breath test and tested 168 on a breath test, and that it would be your first conviction if you were convicted. So the penalties increase the more of these you have. So I'm going to go over the first offense possible range of penalties on this. On the OVI, the maximum penalty is 6 months in jail, $1,075 fine, and a 6-month license, a 3-year license suspension. The minimum penalty, there's a penalty that I can't go below if you're convicted, and that is 3 days in a treatment program, $375 fine, and a 6-month license suspension. That's the minimum penalty on our first offense. Now, your test score, I'm going to explain to you what that means. Let's just say it's 16, and make it easier to understand. The per se level under Ohio law is 8. So what that means is there's a presumption, or there can be a presumption, that someone is impaired if they take a breath test and test at 8 or higher for alcohol under Ohio law. To get the presumption, the state of Ohio has to show they complied with the rules for giving the test, and some of that's like calibration of the machine and that sort of thing. There's some things they have to show before the presumption attaches. Obviously, 16 is higher than 8, so there could be a presumption of impairment here. Do you have any questions about the operating a vehicle intoxicated charge?
Oh, yes, I do.
Okay.
I have one simple question. When I was pulled, the officer told me, or the trooper told me that I was pulled for going, I believe, 60 and a 55. When he initially had pulled me, I told him that I had just left bar in Huntington, and that I'd waited 2 or 3 hours before I even got in the car. I think we left at 11:30, and I was asking him if I wasn't driving recklessly or anything, why was I pulled initially? And he told me that that was the reason. I was just confused as to why, or what exactly he put forth as far as charges.
Okay. Well, we can get into that down the road in some motion hearing, but today's not the trial, today's not a motion hearing, today's just the arraignment. So this is just to make sure you understand what you're being charged with. There could be some legal issues. Under the Fourth Amendment, you have a right against unreasonable searches and seizures, which also means you can't be stopped without, probably may have heard this term, probable cause. There has to be probable cause to stop you. So that would be something that you should discuss with the lawyer, because that would have to be raised by you as a defense. You have 2 other charges. Speeding, and the officer alleged you were going 60 in a 55 zone. That's not a jailable offense. The maximum penalty is $150 fine. And that you were not wearing a safety belt. That's a mandatory $30 fine if you're found guilty. You understand those charges?
Yes, sir.
And you understand the rights you have as a defendant?
Yes, sir.
How do you wish to plead to these charges?
Guilty.
Well, let's back up, back to what I said at the very beginning. If you have questions or you don't understand, or and you just raised a possible defense there, was there probable cause to stop you? I don't know, because I don't know. All I know is basically just the very bare facts right now. Now, if we go further, I'll know more. The state will have to provide additional facts. I don't decide who gets charged. That's not my job. My job is to judge the cases. The prosecutor decides who gets charged. So if you have questions about whether there was a good reason to stop you, that's something that has to be delved into down the road. So, but it's not going to happen if you enter a guilty plea, because if you enter a guilty plea, that's a complete admission that the charges are true. We're not going to look behind the allegations in the complaint. So if you want to look behind the allegations, such as, was there probable cause to stop you, you need to enter a not guilty plea.
I have another question.
Okay.
Okay, so the trooper informed me that if I did not plead guilty, that I would automatically have my license suspended for up to a year.
Well, I mean, you would get you're gonna get if you plead guilty, you're gonna get a license suspension. So, I mean, that pleading guilty is not saving you from anything. That's, you get a suspension with an OVI, there's a mandatory suspension. So that's not a reason to plead guilty, to save yourself from a suspension, because you're gonna get one if you plead guilty.
Yes, sir.
So if you have questions, remember what I said, the safest plea is not guilty. If you don't understand what's happening, if you're confused, or if you got a defense you may want to raise, you got to preserve that by entering a not guilty plea, because a guilty plea is, in legal terms, and this is something that, you know, you're not a lawyer, but an admission, it's an admission that the charges are true, and that means game over. You already admitted that you did it. So if you have questions, you need to enter a not guilty plea.
I'd like to enter a not guilty plea.
Do you want to be considered for a court-appointed lawyer?
Yes, please.
Do you have a job?
Yes.
What do you do?
Yes, sir. I serve at Olive Garden in Ashland, Kentucky.
Okay. Are you paid tips and by the hour?
Our hourly pay is used to pay for our taxes, so I just work off tips.
Okay. Well, I have to determine your gross annual income. Do you file an income tax return?
Not presently. I just moved up here from St. Louis in April, so I've only been there a few months.
Okay. What do you make in an average week?
Around $600 maybe.
Do you have any family that you're supporting?
Yes, I'm supporting my girlfriend, and then we have a baby on the way. She's 35 weeks pregnant.
All right. And I'm going to go ahead and appoint counsel for you then. I'll appoint Mr. Steyr. Not guilty plea entered. He can sign a $1,000 signature bond. Okay, I'm looking in August, and pretty much any date in August is available.
I have a trial set the 18th and on the 21st, but otherwise I'm free in August, so whatever date's best for the court, other than those dates would work.
August 11th.
I'm available.
Next hearing will be August the 11th for a pretrial. That's going to be at 10 o'clock. Not guilty pleas.
Thank you, Your Honor.
Thank you. I'll be out.
Did you hear his concern? He has some legal concerns.
I didn't hear the details, but I understood it had to do with the stop and probable cause for testing.
Yes.
State of Ohio versus Skylar R. Higginbotham, case number TRC 23936, ABC D.
And you're Skylar Higginbotham?
Yes, Your Honor.
Mr. Higginbotham, it's alleged July the 7th at 11:43 p.m. in Fayette County, you were driving a vehicle after consuming alcohol underage. So this is a subsection of the OVI statute. And yeah, you're not going to turn 21 until September, it looks like?
Yes, Your Honor.
Okay. Under Ohio law, it's illegal to consume alcohol until you're 21. If you consume alcohol and operate a motor vehicle, but it's not at the level where you would get an OVI, then there's a separate subsection for those folks that fall in that category, which is what the state's filed against you. And to make it a little more complicated, the state's alleging that you've got a prior alcohol-related offense in 2021.
Yes, Your Honor.
So that makes this a misdemeanor of the 3rd degree. So the maximum penalty is 60 days in jail, $500 fine, and there is a mandatory 1-year suspension of your driving privileges if you're convicted, up to the maximum is 5 years. license suspension. State's also alleging that you were driving 60 in a 55 zone. That's a minor misdemeanor, maximum penalty is a $150 fine. Not wearing a safety belt, that's a mandatory $30 fine. And that you were driving outside your designated lane. That's a minor misdemeanor, maximum penalty is a $150 fine. Do you understand these charges?
Yes, Your Honor.
The state's alleging that you took a breath test and tested 0.6.
Yes, Your Honor.
So, if you were over 21, that would be below the per se level. Well, it still is below the per se level for a regular OVI, but because you're in that status below age 21, it can still be a violation because it shows some consumption of alcohol even though it's below the per se level. So you're charged with this particular statute, which is a third-degree misdemeanor, not a first-degree misdemeanor. A regular OVI has more serious penalties, and it's a first-degree misdemeanor. Do you understand the charge that you face and the possible penalties?
Yes, Your Honor.
You understand your rights?
Yes, Your Honor.
How do you plead to these charges?
Not guilty, Your Honor.
You want a lawyer appointed to represent you?
Yes, Your Honor.
Are you working?
Yes, Your Honor.
What do you do?
I'm a mechanic over at Moses Mall in Huntington, West Virginia.
Okay. Are you paid by the hour there?
Yes, Your Honor.
How much per hour?
$17 an hour.
Are you working 40 hours a week?
Yes, Your Honor.
Do you have any dependents? Do you have children you're supporting?
I have a baby on the way, Your Honor.
Okay, so you're making, according to my calculations, you're making about $35,000 a year gross. Is that right?
I just started, but I wouldn't say that much because after 1 month I go into flat rate as a mechanic's pay to where I get paid by the minute on the job. So no pay is guaranteed.
Okay. So you just eat what you kill then after that?
Yes, Your Honor.
All right, Mr. Smith, I'm going to appoint you, and Mr. Higginbotham has some unusual things he probably
Yes, sir.
wants to talk about today.
Okay.
You would talk with him, please?
Yes, sir, I will.
Admitting you're not guilty. He has a prior of some sort of alcohol-related offense. I can't tell if it's an OVI or prior underage.
Yes, sir.
But it is reflected on the ticket. He is, the state's alleging he's underage, and this charge is underage. Operating after underage consumption. He can sign a $1,000 OR bond. Next hearing, I'm looking at pretty much any dates in August at this point. Do you have any?
I do, Judge. July's bad, August, I'm here the 7th, 14th, 18th, or 21st.
Let's do the 7th.
Yes, sir.
August 7th will be the next hearing, pre-trial at 10 o'clock. Would you like to have the court's file?
If I may, Judge, thank you.
You're welcome. Just make sure the clerk gets it back.
I guess.
State of Ohio versus Rachel Boggs Carter, case number CRB 23374. Your Honor, I believe it's the companion case. State of Ohio versus Donald Carter, case number CRB 23376.
All right, ma'am, you're Rachel Carter?
Yes, sir.
And sir, you're Donald Carter?
Yes.
All right, and it looks like this happened at the same time, but it's two different charges. Ms. Carter, you're charged with failure to confine a dog, June 11th, 2023 in Union Township, as well as you were the keeper or owner of a dog that was not restrained on the premises by leash or other enclosure. That's a minor misdemeanor. The maximum penalty for that's a $150 fine. There's no jail time on that charge. You understand the charge, ma'am?
Yes, sir.
And then Donald Carter, you're charged with aggravated menacing. It's alleged that Union Township, June 11th, you caused Ronnie Gibson to believe you would cause serious physical harm to his personal property. That's aggravated menacing. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand that charge? You have to answer, sir.
Yes, sorry.
And now, what's the relationship between the two of you?
Daughter.
That's my dad.
All right, well, let's start with Rachel. How do you plead to this charge, ma'am?
Oh, guilty.
And then, Mr. Carter, how do you plead to your charge of aggravated menacing?
Not guilty.
Do you want a lawyer appointed to represent you, sir?
I don't know, do I need one?
Well, you probably do. It's first-degree misdemeanor. That's, maximum penalty is 6 months in jail. So I wouldn't do it without a lawyer, and I am a lawyer. So if I got charged, I would get a lawyer to represent me. So do you have the money with which to hire a lawyer?
No,
Do you have a job?
no.
Do you have any income right now?
Social Security.
Okay. We got any other lawyers in? All right, I'm going to appoint Tyler Smith to represent Donald Carter. This is father-daughter, but it is not, she's charged with failure to confine a dog, which she's pled guilty to. He's got aggravated menacing charge, he's pled not guilty to. So I'm appointing you to represent him. Enter a not guilty plea. He can sign a $1,000 OR bond, and I wonder if I'm assuming the prosecutor's office want a protection order. We need them to come in and tell us that.
Your Honor, I believe that Jasmine just went to get their folder.
Oh, okay. Well, let's deal then with, while we're waiting on them to come back, let's deal with Rachel Carter. Is it Rachel Carter or Rachel Boggs? I got one piece of paper that says Rachel Boggs and the other one says Rachel Carter.
Boggs was my married name. I'm divorced. It's Carter.
You went back to Carter?
Yeah, yes, sir.
Well, let me read what the affidavit says, and then if you want to make a statement, you can.
Okay.
This is signed by the deputy, Deputy Riley. It says, I was dispatched, and he gives an address on Route 775 for a dispute between neighbors. Came with Deputy Mullins, spoke with Rachel Carter, Marlena Boggs, Donald Carter, Micah Boggs, and Debbie Jacks. They were advised that the neighbor, Ronnie Gibson, had shot their dog. I saw where the dog had been hit with something, took photographs of the dog. Rachel Carter is the owner, advised me that the dog was on the property in between Rachel's property and Ronnie's property. Myself and Deputy Mullins went to speak with Ronnie Gibson. We made contact. Ronnie advised the neighbor's dog came on his property. He heard some rumbling on his porch. He advised he came outside and observed a trash bag on his porch had been chewed through, that the dog was barking and growling at him. He advised he felt scared and shot it. The dog did not die. It's unknown what type of weapon he was using. He said someone at the other address had fired shots at his house. He does not know who fired the shots. Donald Carter admitted he's the one that fired the shot, but was only at the ground and not towards any house. We had everyone write out statements. I don't have the statements, that's all I've got is that affidavit. So, anything you want to say, Ms. Carter? She pled guilty to the failure to confine a dog.
I mean, the dog was like 4 pounds. We just moved around back with my dad. So he got out and runs. He's hard to catch sometimes, but we got it taken care of.
Okay.
But aggressive, he's like 4 or 5 pounds.
But thinks he's
Yeah.
a lot bigger.
But he doesn't bark or growl at anybody. The officers were there and he didn't do anything to them, didn't bark, didn't growl. I think the biggest issue was his trash on the porch.
Okay. Mr. Yield, any input on this?
No, Your Honor.
Okay. You said you got it taken care of. What have you done?
We fixed him the fence and he's got a different collar and we keep him walked.
Okay.
Yeah, he can't come out.
Is he going to make it? For 4
Yeah.
pounds and get shot, that's probably pretty hard.
Luckily, when he shot him, it bounced through his ear and his spine, off his back. There's pictures of it.
Okay.
But being afraid of a 4-pound dog, he's not aggressive.
Is it a Chihuahua or what is it?
He's a wiener dog and a Chihuahua, a miniature Chihuahua. He's like this big.
Okay. I'll impose a $50 fine and court costs, and I'll suspend all of it on the conditions you don't have any more issues with development
Deal.
to the neighbor's property.
Okay.
So, if you want a copy of the judgment entry, you can get it from the, I'm not putting you on probation, but you can get a copy of the judgment entry from the probation officer to the left as you leave the courtroom.
Okay.
Now, on Mr. Carter, we just need to set a pretrial for him.
That's fine, all right.
I'm pretty much open in August on any dates. Do you have a date you prefer?
I believe I'm here on the 4th of August, so.
I'll set the pretrial for August 4th at 10 o'clock. Not guilty, please enter. Oh, did you want to, is there protection order filed on this, or what? They're neighbors, so this is the neighbor incident over, started with the dog.
So this is Mr. Carter?
Yes.
Protection order on this? We will need one on this case, Your Honor.
Okay, so I'm not requiring you to move or anything, but I don't want there to be another incident, that's the main thing. So just stay away from Mr. Gibson, don't approach him, don't go around him, don't post things about him on social media. Let's just let everything die down, come back to court on August the 4th.
Thank you, sir.
You're welcome.
State of Ohio versus Lincoln Hall, case number CRB 23377.
Ma'am, are you Latham Hall?
Sir?
Ms. Hall, it's alleged that at Rome Township on May the 8th of 2023, you purposely deprived Stephen Martin of property, $568.11, and that you did so without his consent. So the charge against you is theft. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. You understand the charge?
Yes, sir.
You understand your rights?
Yes, I do.
How do you plead to the charge?
Not guilty.
Do you want a lawyer appointed?
Yes, sir, I do.
Do you have a job?
Yes.
What do you do?
I clean houses.
What do you make a week?
About $300 a week.
Okay, you have to fill out an affidavit that verifies that.
Yes, sir.
I'll appoint Mr. Morford to represent you. He is here. We're going to get him in the courtroom and introduce you. I'm entering a not guilty plea for you.
Thank you.
And you can sign a $1,000 signature bond. Do you understand what that means?
Yes, sir, as long as I come back.
Yeah. It's just your problem. I'm appointing you, Mr. Morford, to represent Latham Hall. It's on a first-degree misdemeanor theft offense, not involving Walmart. She's entered a not guilty plea. She can sign a signature bond. I'm open in April and August for hearings, pretty much any body. What's your preference?
Judge, I'm pretty free. Pretty much free.
Let's do the 11th then, August the 11th. August the 11th for pretrial, 10 a.m.
State of Ohio versus Ronnie Lee Gibson, case number CRB 23375.
All right, sir, you're Ronnie Lee Gibson.
Yes, sir, I am, Your Honor.
Mr. Gibson, it's alleged that Union Township, June the 11th, you did torture, mutilate, maim, kill, I think in this case it'd be killed. A companion animal in violation of the revised code. That is a first degree misdemeanor, maximum penalty 6 months in jail and a $1,000 fine. You understand the charge, sir?
Yes, Your Honor.
And you understand your rights?
Yes, Your Honor.
Any questions before you enter a plea?
Will I get a chance to make a brief explanation of?
Well, today's not really the day to do that because it's not, I can't do anything with it. Like if you say, here's the guy you got to convince. If you make some explanation that says, oh, I don't want to pursue this case anymore, fine. He's the prosecutor. But
Yes,
today's
sir.
not the trial, so
Yes,
they get a
sir.
right to present their side of it. Then I
Yes, sir.
make a decision. So
Yes,
I
sir.
can't just dismiss it on your say-so.
Yes, Your Honor.
You'd have to convince him to dismiss it today. Down the road, I'll get to make that call. Does that answer your question?
Yes, Your Honor.
So it's the smarter play is to wait and talk to your lawyer. 'Cause whatever you say here is on the record. And you admit, you may not even think you're admitting something. You admit something that helps his case, he can use it against you at a trial. Do you wish to be considered for a court-appointed lawyer?
No, Your Honor. I already checked into it, and I make a little too much money to qualify.
Okay. I think, when did I set that, those other cases? When I set them the same day?
Who were those?
Carter, yeah, Donald Carter. I think it was, no, was it Morgan? I think it was Tyler Smith.
Tyler Smith, yeah, Tyler Smith.
Well, look at, you can just look up Donald Carter. I think it's the 11th. I was wrong. I was only off a week. Can you get a lawyer by August the 4th?
Sir, I've already consulted attorneys, and the prices they want, I cannot afford.
Okay. But you don't want me, I can consider, you may not qualify, but I could ask you about your income. It's a sliding scale. The bigger your family is, the more you can make and still qualify. But I have a scale I have to go by for appointment of counsel. You want me to ask about that?
No, sir.
Okay. I'll set it for August the 4th for a pretrial at 10 o'clock. And you can sign a $1,000 OR bond, and likewise, if you want him ordered to stay away from Mr. Carter, would that be, he's not a victim in this case, but he's the neighbor.
I was going to plead no
Well,
contest.
he's asking if we want protection. Is there a criminal that was in this?
So this is a animal cruelty,
Right.
so I don't know that we are able to have a protection order. I mean, we would prepare one for sure.
You can do a condition bond, but you can't do the
Okay. We don't believe we can do it. We
All right,
can do it
here's
as
what I'm
condition
going to do. I'm
bond.
going to let you sign an OR bond, but I'm going to make a condition of that. You just stay away from Mr. Carter. I want you two to stay away from each other while this is pending.
Absolutely, Your
Just don't
Honor.
go around each other. Come back on August the 4th at 10 o'clock.
Yes, sir. I wanted to plead no contest.
I'm sorry, sir.
I was going to plead no contest. I hadn't pled yet.
Oh, I thought you said not guilty.
No, sir.
Okay. If you enter a no contest plea, what that means is you're not fighting the charge. You're agreeing you can be found guilty, but you're not admitting that it's true either.
Yes, Your Honor.
Is that what you want to do?
Yes, Your Honor.
Okay. And it's probably the same affidavit, but let me look and see. Yeah. Well, here's the thing. I don't know that this, I don't think it's a good idea, and I don't know that I would accept a no contest plea, because you may have a defense. And if the dog is on your property,
Yes, sir.
I think that's a defense that you have to this case.
Yes, sir, that's what an attorney told me, but he wanted so much money, there's no way I can pay.
Okay, well, I'm not gonna accept a no contest plea, because that's an apparent defense to me on the face of it, that the dog came on your property,
Yes, sir.
and you shot it on your property,
Yes, sir.
so I will not accept a no contest plea. So I'm gonna enter a not guilty plea for you, and set it for a pretrial on August the 4th.
Yes, sir.
Now, the state they may take a different view of the facts, but that's what appears to me, at least on the face of it.
Yes, sir.
So, August the 4th, 10 o'clock is your next hearing.
Does he need to sign a bond, Your Honor?
He does, $1,000 over.
What's that mean, sir?
As long as you pay $1,000.
Yes, sir. Yes,
Just
sir.
sign that there, Davis.
Yes, sir. You say August 4th?
August 4th.
What time was that, sir, on August 4th?
10 a.m.
Yes, sir.
State of Ohio versus Che M. McCoy, case number CRB 23357. Che McCoy.
For you guys.
Not checking at the door, Your Honor.
All right, thank you. Che McCoy's been called for, has not appeared. He signed a certified mail receipt for a summons on June 21st. And that summons ordered him to be here at 9 a.m. today. He's failed to appear, so now a warrant will issue for failure to appear.
State of Ohio versus Tamari Cave, case number CRA 21909 and TRC 213569, A, B, and C.
All right, you are Tamari Cave.
Yes.
You had a hearing on Monday, it looks like, on a review, and you missed that, is that correct? You have an explanation?
Yeah, after you gave me that court date the last time, I went out there and told the clerks that I have a court date the same date and the same time in another state. And they kind of looked over that, and I called multiple times over the next several weeks. And then I believe her name is Larissa, told me that as long as I'm here within 7 days of that court date, that there will not be a warrant issued for my arrest. So I appeared today.
Okay. And you still have a couple days community service, you've paid your fines.
I actually completed my community service. They just didn't have time to write out a paper yet, so I'll be bringing that in. And then my OVI class, I go to that next Thursday on the 20th.
In Scioto County?
In Chillicothe.
Chillicothe, okay.
Yes.
All right, there actually has not been a warrant issued yet, so there is a 7-day grace period. So it won't be entered, no warrant will be entered, and I'll set your next hearing for August the 28th. As long as you get everything in here and filed by then, you don't have to come back for that hearing.
All right, thank you.
You're welcome. 9 o'clock, August 28th, get your 3-day school filed, and your, if the completion of community service is registered, you don't have to.
State of Ohio versus Jessica Leggett, case number TRD 211157.
All right, this was set for review June 26th. You also go by McMahon?
Yes,
Which name is correct? current?
Leggett.
Okay.
Your Honor, if I may, she was in our care as of, I believe, the correct date is May 8th. Since we have known her as McMahon, I was not aware to be looking for the alternate last name on the docket. So that would be an issue on our part.
Now, what, is she currently inpatient or outpatient?
She is inpatient, Your Honor.
Okay. And she was there was she there then when the date occurred and missed it because of the mix-up in the name?
Correct.
All right, so I'll cancel the warrant. Any time frame on her treatment regime?
August 8th. August 8th.
You're graduating August 8th? Okay. All right, I'm going to have you come back in 1 month, then, August the 14th, and we'll get a report. And what's the plan after you graduate? What are you going to do?
Outpatient.
Are you working at Subway?
Yeah.
Okay, very good.
Yes.
Okay, I'll set your next hearing August the 14th at 9 a.m. Good luck.
Thank you.
Thank you, Your Honor.
State of Ohio versus Stephen L. Murphy, case number TRC 2270, ABCD&E.
And you're Stephen Murphy?
Yes, Your Honor.
Okay, and you had a review hearing Monday.
Yes, sir.
And you've been at TTC?
What, Your
Counseling
Honor?
Center?
Yes, sir.
Are you still there, or what's?
No, Your Honor.
Did you graduate, or what?
Yes, Your Honor, on the 13th,
13th of?
last month.
Okay, I need a report from them just showing that you completed.
Yes, sir.
And then I also had note that you are a veteran.
Yes, sir.
Are you getting any services from the Veterans?
Right now, transportation, well, I missed Monday. I'm trying to find it right up there and get everything taken care of.
The one in Spring Valley?
Huntington.
Yeah.
Yes.
Spring Valley.
Okay.
Yeah, they have a really nice facility, and have been very cooperative with this work, so.
Thank you.
I think, and they have a lot of assets that they can help you with, so I think it's a smart move on your part to get involved with them, and let them help you.
Yes, sir.
Okay, I'm showing you still owe some community service and fines, and I need a report on your finishing up your treatment. Okay, I don't, hasn't been a warrant actually issued yet. One won't be issued because you came in today. I'll set your next hearing for August 14th. Do you have any job prospects, or?
I'll watch the kids during the day. I'm trying to find a night shift job at the moment.
Okay. August 14th, 9 o'clock will be your next hearing. And do you have contact information for the veterans?
A few numbers, yes, sir.
Okay, because we've got a liaison that works with the court quite a bit. If you want her phone number, and she can plug
Yes,
you in. If you want to go to the probation office, he can give you the phone number, how to get out in touch with her. She's been very helpful with other people we've had through the court.
Thank you, Your Honor.
Her name's Manny.
Manny? All right, thank you.
You're welcome.
State of Ohio versus Brandon Masters, case number CRB 23421. Brandon Masters. Brandon Masters.
All right, Brandon Masters was released from the jail due to overcrowding and ordered to appear today at 9 a.m. Has not appeared, so there'll be a bench warrant issued.
State of Ohio versus Brock C. Smith, case number TRC 2015-1599, A, B, and C, and CRA 2706.
And you're Brock Smith?
Yes, sir.
All right, this is a case, it looks like a warrant's been outstanding for a while, since the fall of 2022 on, looks like there was an ODI and possession. You paid your fines. I see, like on one of these, there was some ordered treatment, so I don't know. Yeah, you were at Valley Health, supposed to go to Valley Health for some treatment. Did you do that?
No, you sent me to jail.
Well, I'm looking at your judgment entry. Yeah, you did get some jail time, but you got suspended jail time with an order to continue alcohol and drug abuse counseling with Valley Health. And you had a possession of drugs that was a felony, was reduced to a misdemeanor order that you complete treatment at Valley Health.
I thought the 10 days was in
Apparently you
lieu
had
of
been
that.
there because I have a report from Valley Health saying that you were under their care at one point. Is that right?
Yes, sir.
Okay, well, under the circumstances, why'd you show up today?
Because they had a warrant out for my arrest.
And you found out about it?
Yes, sir.
How'd you find out?
I got pulled over in hanging route.
Oh, did you post a bond?
Yes, sir.
Okay, well, I don't think I have that. Do not have the bond. When was that? When did you get arrested?
I think it was Monday.
Okay, so there must be a bond somewhere in the clerk's office. Okay, here's what I want to do. I want you to go do a urine screen here, and after I get the results, I'll have you back and I'll decide how we're going to go forward. So Mr. Cooper will show you where to go do a urine screen. Okay, we're going to start some of the pre-trials. We have some arraignments to do from the jail, but we're not quite ready to go there yet.
State of Ohio versus Heather A. Blevins. Case number CRB 23-158, TRC 23-261, A, B, and C.
We're going to have to see.
All right, this is Ms. Scott's case, Heather Blevins. Scott is here, so ma'am, you can just come up to the table to your right, stand there, she'll be in. So this is the case we discussed this morning?
Yes, Your Honor.
Okay. So it's my understanding it's going to be a change of plea, but we're going to delay sentencing while she does some work.
That's correct, Your Honor, and then I also have an agreed entry along with Mr. Field for driving privileges.
All right.
May I approach?
Yes. You would tender that to the court, please. I'll approve your entry. It's in the file to be timestamped. So come back in approximately a month and we'll get a report then as to what she's doing with her counseling.
Yes, Your Honor, may we both appear via Blue Jeans at that time?
Yes, if she's compliant, if she's doing what she's.
Yes, sir,
needs
and
to
I'll
do.
make sure that we have all of that information to the court as well.
Okay. August the 14th, do you know what agency she's going to go to at this point?
I'm going to encourage her to do the counseling center since that is the one that you have suggested, Your Honor.
That's one we work with quite a bit. that's
Yes, Your Honor.
inside of the county, so.
So could August 14th do video at noon or?
That's fine.
Okay.
We'll set it at 12 p.m. I'll make a note, you can't appear by Bluetooth. You have that app?
Yes, Your Honor.
Okay. Anything else?
Yeah, not at this time, Your Honor. So should she see a probation officer and things today?
I don't think
or-
now, I'm just going to make a note that there is a guilty plea
Okay.
with delayed sentencing. And
Okay.
you agree with that, ma'am? You're in a guilty plea, and we're going to let you, the better you do in treatment, the better I can do on your sentence. So, ball's in your court now. So, what I want to be convinced of is that this isn't going to happen anymore, that you've dealt with whatever issue brought you into court, and you're not going to be out there.
This will be like triple 3 times with me in counseling, so I'm doing very good now.
She's engaged also in mental health counseling as well, Your Honor, as well as AOD services, so,
Okay.
and we're gonna, and then she's gonna add the counseling center on. I'll just speak to your staff about how best to get those reports to your court before
Right,
I
to-
leave.
To the probation officer.
Okay,
Yes.
thank you, I'll make sure we have that information. Thank you.
You're welcome.
State of Ohio versus Dale M. Thompson, case number CRB 23237.
Mr. Haslam's case, for pre-trial. Dale Thompson.
Your Honor, yesterday afternoon, after the court was closed, Mr. Thompson advised my office that he did not have transportation to get to court today. I've spoken with Mr. Heald, and I know the court does not prefer that we do continuances the day of, but I would humbly ask the court to continue Mr. Thompson's case. We would waive time for the period of the continuance.
Mr. Heald.
We're not opposed to that, Your Honor. As a matter of fact, I intend to speak to some of the witnesses and the alleged aggrieved party in this in order to determine if the circumstances have gotten better. Because one of the things that we discussed previously was Mr. Thompson taking steps to make sure his dogs don't get out, like a fence and things of that nature. So we want to follow up on that to see where we stand. So we're okay with the continuance.
Okay, I'm setting cases in August now. Pretty much any court dates in August are available. Do you have a preference, Mr. Haslam?
If you'll bear with me 1 second, Your Honor. For August, Friday, August 11th, Your Honor.
August the 11th will be the next hearing, pre-trial at 10 o'clock.
State of Ohio versus Tyler Wellman, case number TRC 23316, A and B.
All right, this is set actually for a pre-trial today. Tyler Wellman, Mr. Haslam's case.
Your Honor, we're going to have a change of plea today. Mr. Wellman has agreed to accept the state's offer to plead to a first offense OVI, completion of the 3-day dip school in lieu of any jail time, plus any appropriate fines and costs imposed by the court.
Mr. Heald.
We are requesting the minimums, Your Honor.
All right, Mr. Wellman, do you agree with your attorney, what your attorneys represent to the court?
Yes, sir.
Do you have any statement you wish to make? You have a right to make a statement. You're not required to before sentencing.
No, sir.
All right, I'll impose a $400 fine, order that the cost be paid. 6-month license suspension, that started the day of the incident, so it'll end in September. 20 days in jail, all suspended. 5 days of community service, 2 years of level 4 probation, required to go to the driver intervention program. Unfortunately, there's not a program here in Lawrence County anymore. The closest one is enforcement, but there's others. We just had someone that said they're going to one in Chillicothe. So you can go to any approved 3-day program by the state of Ohio. But you have to do that, and I think you're a West Virginia resident, I believe. Yes. So the DMV in West Virginia requires it too, so you got to do it.
Permission to approach, Your Honor, with the ALS termination form?
Yes. Let's see, there was a B case. What's the B case? traffic, oh, that was the stop sign. $10 fine.
Your Honor, may he have work privileges for driving at this point in time?
Yes, he can have privileges for work, community service, go to the 3-day program, and to come to community service.
Yes, sir, and I'll prepare an entry report.
You can have the file and this entry if you want, make sure it gets filed.
Yes, sir.
And you'll need to check in with probation before you leave.
Yes, sir.
And his review hearing will be January 12th of '24. So if you finish everything before January 12th of next year, you don't have to come back. You got stuff you haven't got done, you got to check in, explain why you didn't get it finished, ask for more time. You blow it off, you get a warrant for not showing up. See the probation officer before you leave.
Thank you.
State of Ohio versus Kevin Browning, case number TRC 23690, A and B.
Mr. Smith's case set for pretrial.
It is, Judge. We had filed discovery. It's been answered. Sarah, before she left, indicated that she had not received the Axon body cam video, and Missy is checking on that. I would ask we come back sometime in August so I can review the video with my client.
August 11th.
Let's see, Judge. I think that's actually a date I'm in trial. I'm here the 7th, 14th, 18th, 21st.
14th.
I can do that, yes, sir.
August 14th.
When I get back, August 14th at 10. Thank you, Judge.
10 a.m., August 14th.
State of Ohio versus Austin Day, case number CRB 23371.
Mr. Smith's case set for pretrial, Austin Day.
No, well, I can do one.
So this is another case. We're awaiting a video. I know there was a subpoena issued by the state to have it here today. I don't know if the representative from Walmart is here with the video today, flash drive. Missy was checking on that. But what I'd like to do, Judge, use that same August 14th date if it's not too busy.
That's fine.
To review that video.
Next hearing at defendant's request is August 14th for pretrial, 10 a.m.
Thank you, Judge.
Can you do one for everybody?
State of Ohio versus Sebastian N. Evans, case number CRB 23349, A and B.
This is Mr. Schreier's case set for pretrial.
I think, but don't know that we have an agreement reached on this.
Your Honor, we just consulted with the victim in this matter. There's actually two cases, one involving her and then her child. They're two domestic violence cases. And our offer at this time is 180 days in jail with 170 suspended. No contact order, 2 years probation. And we would take no position on any other sanctions. And again, that has been approved by the victim.
While you're on probation. The only thing I would add to that is I believe a civil protective order has been, let me look at this, I think, looks like a civil protective order has been sought and has a hearing date on the 24th. I think the alleged juvenile victim is Mr. Evans' son, so I think there's probably going to be some proceedings in juvenile and probate court. So I would ask that we would agree to the no contact order initially at least, but I would ask that it just be stated that it would be subject to whatever rulings happen in common pleas court, if the state would be agreeable to that.
I don't know if there's a mechanism to do that.
I think it could just be written in there that subject to the orders of common pleas court. Then if a violation was alleged later, we could say, here's the other order. I mean, I may be wrong about that, but I think that seems like a reasonable way to
We're
deal
willing
with
to
it.
do that. You'll have to write it in, and the
Sure,
court
that's,
will approve it.
well, I mean, it's obviously up to the court whether to grant what I'm asking for anyway.
So, I'm fine with that. So he's gonna serve 10 days of actual jail time?
He is, he has his hearing on the, he has a couple other hearings coming up, so we're gonna ask for a report date after the 24th. Would you rather come in on a Friday or a Monday?
Friday.
So we would ask for, I think the Friday after the 24th is the 28th. So we would ask that he report on the 28th.
That'd be perfect.
And we would enter a guilty plea with that, enjoy the recommendation.
Is that correct, Mr. Evans?
Yes, Your Honor.
You have a right to make a statement if you want. You're not required to. You
I'm-
make any statement?
I'm okay. Thank you.
Yeah, I'm gonna review the affidavit. It was pretty short.
If I may, Your Honor, what time would he report here? Is it still
11 a.m.
11 a.m., okay.
All right, I'll impose a $250 fine. Court costs.
I can pay that today, Your Honor?
Yes. 180 days in jail, 170 suspended. No contact order, subject to orders of common police court. He'll report here on July 28th at 11 a.m. to start his 10-day jail.
You gotta come here on 28th at 11 a.m.
And then that's when I start my
And,
protest.
this will be 2 years of level 4 probation. This review hearing will be January the 12th.
I'll come out and talk to you about it. What day did you say, Your Honor? I apologize.
January 12th. His report for jail date is July 28th, so that'll be the next time we talk at 11 a.m. Report for jail. You come here to the court to report to jail.
And then January 12th, I have another court date?
You got a review hearing. That's a hearing to check and make sure you're doing what you're supposed to do on the other things. So if you get everything finished, you don't have to show up. If you have stuff left to do, you got to show up.
Yes, sir.
And you're going to check in with your probation, and there is a no contact order too.
Well, Your Honor, actually, I looked back at the notes, and the victim, because of the fact that she's seeking a protection order, CPO, that she did not request a no contact order.
Okay, there will not be a no contact order.
I think on either case, Your Honor.
On either, yeah.
So there's no contact, there's not no contact?
No, there's whatever's going on in common police court is all subject to that.
Okay.
So there's actually there's two domestic violence. There's
Yes.
A and a B. Okay, on the B case, I'll just impose a $100 fine.
And there would be a single set of court costs, Your Honor, because it
Yes,
rises from a single
one court
incident.
cost.
Then that should, where it says no contact order, verbiage that's still subject to common police court.
Yeah, I would do that in, because that's the order that's going to control the contract. But I would take out the next one, because that's a particular type of
So
order.
how do you want that, I just don't have it, could you please say how you want that stated in this statement?
Let's change it to contact with the complaining party, subject to orders of common police court.
Well, I asked her that, and she said that was going to bring us, so I mean, we can do what you want.
It's too late.
Okay. Anything else?
Nothing from the defense, Your Honor.
Check in with probation and just review it.
State of Ohio versus Jared Monroe Rocknon, case number TRC 21-2826 AP in the city, CRA 21-597, CRB 21-598.
Mr. Stiers' case.
She's the next court date.
So she said she's going to try to find me for her fund. So you don't ask for the fund. They do like the 10. She already has one that's going to the fund. She said for the fund. All right. I mean, that's what she kept on saying.
21, 28, 26, TRC case number. 21, 597 is CRA. 21, 598 is CRB. Well, this is a problematic case. Mr. Brogman has started back in the fall of 2021, and then he's been in, this is at least the third treatment facility he's been in, and he's disappeared for long stretches of time. And his last, I'll just quote from his last report, he's currently in Southern Hope, and I assume he self-reported there before he came to court. Jared does not appear to accept and understand the importance of recovery. He is not serious. He has impulsive thoughts and behaviors, codependency issues, problems with accepting responsibility. And he has a felony, so I don't know if he really belongs in this court. Go back and I see a report from Hometown Recovery back in November of 2021. His intake date there was October the 18th of 2021, with an estimated out date April the 18th of 2022. He's currently non-compliant with treatment recommendations. He violates policy and procedures of agency, resistant to treatment recommendations, disrespectful to peers and staff, is placed on a behavioral contract. So this may be a gentleman that just needs to go to the grand jury.
We have an OVI pending, which is not connected, which would still need to be resolved here. We have a domestic violence charge that occurred at the same time as the disrupting public services, so it could go to the grand jury.
That's 21,598.
Yes, and we're in agreement that this has gone on. Well, I mean, I don't know what's happened for the last year and a half.
Yeah, he was gone. He had a pretrial on January 31st of 22 that he's not appeared for. A warrant was issued, and he's not back here. And he appeared sometime between now and today, because it was separate here today.
It would help us in making a recommendation as to what to do if we knew where he'd been for the last year and a half. If there was an explanation.
If I may. I was up north where I'm from. My grandma had a stroke and my sister died. Back in April.
If I may, Your Honor, even if the felonies were to continue on to the grand jury, we'd still have the OVI that would have to be dealt with here. I filed discovery on it back when this first all started, but I'll be honest with you, I don't remember the details of the case now 2 years later. So I think it's going to continue on here at any rate, at least briefly. So I would ask that the state and that the court allow us to continue on here, at least to see where things are going. And although I agree that some of the commentary in there are some problems with the comments in the report, It does say that at this time, he is continuing to meet all program requirements, or all treatment requirements, and I have a completely clean drug screen attached, and that he is working on stabilizing and treatment. I do think that things aren't going great, but I feel like compared to where we were before, where we didn't have compliance and a questionable attitude is progress. And while we're not where we want to end up, I think we're on a path that is in the right direction. So I would ask that the court, Mr. Hill, allow us to remain on that path and see if we can't, see further improvement.
Well, here's my concern. And I've said this before, that this is a court for people who want to get in recovery. And I want to help them get in recovery. But when you take someone who flaunts the system, leaves and disappears for a substantial period of time, and then just wants to walk back into court and act like, I'm here now, and I chose where I want to go to treatment, and I get to just hit the reset button and start all over again. That's a bad precedent to start. Of all the other people that are in treatment, if they decide, hey, I'm going to take a break for a year and a half, I'm going to just go out, I got some family issues. Who doesn't have family issues? Everybody's got a family issue that they can blame and say why they're leaving treatment. I think there's got to be a price to pay for that. I don't think you can just walk back in and say, okay, I'm back, I'm choosing where I want to go to treatment, accept it, deal with it. I got a big problem with that. Mr. Hill.
Your Honor, I have a suggestion. We agree with the court on the issue of just coming back and feeling like we can just pick up where we left off. I do agree that Mr. Steyer should have a little bit of an opportunity to look at the facts of the cases or whatever and come back in a week or two. But if they don't want to resolve some things and accept some punishment in addition to treatment at that time, then we would take the domestic violence and the disrupting public services to the grand jury. So our suggestion is going to be that if there were a plea to the domestic violence and the OVI, we would recommend a 6-month jail sentence in which he would do some actual jail time. And we would discuss that, and then he could resume his treatment. So he'd have the remainder of 6 months over his head, or delay sentencing, but have him do some, I don't know if that's possible, but I think some jail time is in order because of the circumstances. So if that would be our recommendation if they want to do that. In the meantime, he could get another report from the agency, maybe that might be more favorable to him.
You want to discuss it with him and have it recalled?
Yes, I'd like to do that, Your Honor.
Okay, we'll recall this later in the document.
Grab your glasses. Wait for me out there, please.
State of Ohio versus Philip and Highland, case number CRV 23-192.
Your Honor, I believe this one has a companion case. Mr. Morford represents the cross complainant.
Another name?
April Galloway. April Galloway here?
Yeah, I'm here.
Okay, you come up now. I need Mr. Morford in the courtroom, please.
State of Ohio versus April Galloway, case number CRV 23-190.
Mr. Morford, around? Mr. Morford.
Yes, sir.
Oh, I'm sorry. I didn't see you. All right. You're representing Ms. Galloway.
Yes, Your Honor.
Is representing Mr. Hyde.
Yes, Your Honor.
There have been no further problems, Your Honor. It's my understanding that the state would agree to dismiss the case upon payment of court
I
costs.
understand he's paying the cost.
That's correct, Your Honor.
Is he prepared to do that today?
I can't do it today, I can do it next week. I just started a job, I don't get paid till next week. I can pay a little bit on it today, but I can't pay.
Mr. Hill?
Well, I mean, we're not opposed to a short continuance that, and if it's paid, then they wouldn't have to appear.
Okay, when can you have it paid off?
I can have it paid by Friday.
Well, let's build in plenty of time that you're going to get this done. How about if we make it August the 4th and you don't have to appear if you paid it by then?
You can come in next Friday and pay it.
You can pay it anytime before August 4th.
You just don't have to come back.
And no appearance required. If it's not paid, do we want to just go ahead and dismiss hers because he's the one that was paid? So I'm going to dismiss Ms. Galloway's because hers was without cost, so she doesn't have to come back. But he does if he hasn't paid the cost by August 4th. If you paid it by then, you don't have to pay it.
Good deal. Good luck. Thank you, Your Honor.
Okay. You understand what you need to do, Mr. Highwood? Yes, sir. Okay.
State of Ohio recalls Brock C. Smith, case number PRC 2015-99, A, B, and C, CRA 2706.
Did you see the test result?
Yes, sir.
And what do you say about it? Do you have any explanation?
No, sir.
Well, one of the things you were ordered to do for it was get some counseling, and it looks like there's still a need for it.
I do have to go to counseling.
Are you going anywhere now?
Yes, sir.
Where?
Brightview Health
And where's that located?
in Portsmouth.
Bright View or Brighter Days or? Is that where you're getting your buprenorphine?
Yes, sir.
Well, part of your order was you get treatment. At that point, you were at Valley Health. Were you living in Huntington then?
No.
Well, I had a report from them, so you were seeing them for some reason. I don't think they're in Portsmouth, are they? Or you live in Portsmouth or South Point at one point, right?
No, I live in Ironton.
Live in Ironton, okay. Okay, I'll withdraw the warrant, give you a new review hearing date. And give me some reports on your treatment, and let's get clean drug screening. Okay?
Yes, sir.
Okay, I'll see you in a month. Let's make it August the 14th. I want a report from your treatment provider, and you're subject to getting a screen then, too. We'll see how you're doing. You gotta fix that issue. And let me just say this, Mr. Smith.
Yes, sir.
You getting anything out there off the street is really dangerous right now.
I haven't
There's a lot
taken
of
anything
fentanyl.
from the street.
Okay. Well, you tested for amphetamine, so I don't know if you had a prescription for that or not. But if you, maybe you're not, but just as a warning. Even if somebody says, well, here's an upper, take it if you're feeling bad. If you don't know it came from a pharmacy, you didn't get it prescribed yourself, it could be fake. There's a lot of fake stuff, and a lot of it has, people are overdosing and dying on fake pills that they think something else other than what they're taking. And even if you buy methamphetamine or something else, it could have fentanyl in it. It's dangerous, very dangerous. So best thing is get clean. Don't do anything off the street. That's the goal. August 14th, we'll see you back and bring me some stuff from your provider as to what you're doing. And once I'm convinced that it's not going to be an issue anymore, you can stop coming to these things.
Yes,
August
sir.
14th, 9 o'clock. Okay, we're going to start teleconferencing with the jail.
State of Ohio versus Austin Carmen at the Lawrence County Jail, case number CRB 21697, CRB 2097. And Reggie Krantz is on deck.
Okay, this is, Ms. Megan, this is an old case that was sent to QRT quite a while ago, so I don't know if there's any record on it, but Austin Carmen, that's you, sir?
Yes.
I'm Judge Capper, and this is an arraignment on a warrant for failure to appear. It's alleged that you had failed to appear for a pretrial back in January the 7th of 2022 on these cases. And also alleged in that you were non-compliant with treatment at Riverside. You've got a case that you were sentenced on disorderly conduct, and then you had pending aggravated menacing, what was still pending and hasn't been resolved. Mr. Thompson's your lawyer. He's not here. I have a report from Riverside Recovery, now the artist formerly known as Riverside Recovery Services, now RRS. It says, Mr. Carmen, this is dated January the 7th, 2021. Mr. Carmen is non-compliant with the terms of his treatment. His requirements have been an individual session and 2 groups per week. At a face-to-face on December 10th of 21, he expressed hardship, interference with meeting requirements. The counselor agreed to lower requirements to help him in meeting employment obligations. He still failed to meet the requirements and had no service or contact until December 30th, 2021. And then he didn't show up for court, it looks like. All right, your attorney's not here. Okay. Okay. Well, he does have a case scheduled today, so I'm assuming maybe he will be showing up, but he's not here currently. So let's do this. We'll contact him, make sure he knows you're on the docket, and he has another case on the docket, and we'll recall it when he gets here.
State of Ohio versus Reggie A. Krantz, case number TRD 1932-35 A, B, and C, CRB 18516, TRD 181303, CRB 1834. Nathaniel James is on deck.
What's the other case, Mr. Thompson?
C1. 11C.
What is the first name?
11, C1.
Okay. We'll recall Mr. Carmen later. Reggie Krantz. Yes, sir. Okay, it's alleged you missed the hearing September 9th of 22.
It's just showing up as a regular hearing on
Oh,
our
okay.
computer.
Yeah, it looks like he was arrested and arraigned on July 3rd, and then this is a review hearing for today. Do you have a holder from another court, Mr. Krantz?
Yes, sir, from common pleas out of probation.
Have you appeared in that court yet on your probation issues?
No, sir.
So maybe that'll happen next Wednesday?
Possibly, yeah.
Do you have a lawyer in that court?
Yes, sir.
Who's your lawyer?
Well, I got a possession of heroin, and they hit me, Davenport. That was through Judge Waldo's court, and now I'm waiting to go. I was on probation with common pleas, and I got a possession charge while I was on probation.
So the possession is a new charge,
Yes, sir.
and that caused a probation violation charge?
Yes, sir.
Okay. Want to just keep continuing this until he appears in common pleas and figure out what's going to happen there?
Yes, Your Honor.
Okay, so there's a good shot that maybe you'll appear on the 19th of July in common pleas. That's a Wednesday. So why don't we set this for the 21st? So that's the Friday after.
This is Mr. Stratton's case, isn't it?
Who is this? No, I mean, I think these were all reviews.
Oh.
And it was, Luke Steyer was the initial attorney, and then Mr. Nip was one of the attorneys way back in the day.
I had the wrong file. I was looking at the next case.
Reggie Krantz.
Yeah.
All right, July the 21st will be the next, I'll just set it as a regular review. So if you get out, you have to come to Chesapeake on that date at 9 o'clock. If you're still in the jail, we'll do it just like we're doing today by teleconference.
Okay.
Because you still got stuff here you got to take care of.
Yes, sir.
Any questions?
Yes, sir.
So that's the Friday after, well, next Friday, 1 week from today.
State of Ohio versus Nathaniel James, case number CRB 23317. Jeremy Jenkins is on deck.
Your Honor, this was the case of the gentleman who was supposed to go to RRG but was unable to because he has an arson charge or a past arson charge. So question today, I guess, is where can we send him?
And he has West Virginia Medicaid.
Yeah.
OVP? You want to try to contact them and see if they...
Yeah, we can do OVP. Do you have anybody here today, or?
I don't think so.
Oh, okay.
Haven't seen anybody. So you want to try to contact them?
Yeah, I'll call them.
All right, we'll recall Mr. James later in the docket.
Did you have my lawyer call him?
He's right
Yeah, I'll
here.
call you.
Okay.
I'll call OVP, then I'll call him.
Okay. We'll have you back on teleconference after he finds out something. The place you were referred to before refused to take you because of some of your history.
State of Ohio versus Jeremy D. Jenkins, case number CRA 22816 and CRB 22817. TRD 222781, A, B, and C. Branson Johnson was on deck.
On the last case, I'm texting Mr. Thompson. Okay. Jeremy Jenkins is Mr. Morford's case. And he has a felony and some misdemeanors. He had been referred to QRT. I believe there was indications that he relapsed, and he refused to follow up. He'd finished inpatient, didn't do what he was supposed to do for follow-up outpatient.
Right. So we
And came in here and tested dirty.
Yes.
And he was supposed to report to RRS on Monday or Tuesday? Tuesday morning at 9 a.m. He promised to do that. He had to go home and take care of his dog. I remember that.
He never showed, Your Honor.
He did not show up. He got a warrant issued, and now he's in the jailhouse now. So what do we do with Mr. Jenkins? He's got a felony. I don't really understand this, because if I had a felony, I'd be scared of going to prison.
But there's just so much more follow-up that comes with it behind it, and I'm just ready to just
Go to prison?
do my time. I'm just ready to just do my time and get it over with.
Pretty much sums up what he was telling me.
If I was go back, if I was to Riverside, then I'll have 10 months in on a 12-month discharge, and then I still got to go to I mean, it's just a lot of unnecessary time.
It makes no sense not to go to treatment, Mr. Jenkins.
And in the meantime, he tested for amphetamines, buprenorphine, benzodiazepines, ecstasy, and methamphetamine last week, July 10th.
When I spoke with him in the hallway, he was not wanting to go to treatment, and he was not wanting to participate in QRT. I didn't figure he would show up.
Okay.
Mr. Jenkins?
I think everything he's got can go to the grand. Let's see, he's got some misdemeanors, but I think they all happen on the same day, all the same incident. Let's see, if I'm not right.
Mr. Jenkins, this is much more for your attorney. Going to treatment will also do you well when you get to common pleas court.
But common pleas just want to sentence me anyway. I'll just take my time with him.
Well, that's your choice.
Yeah, every case that he has, where it's a misdemeanor or a felony possession, all goes at the same time, the same day. So, So how's the state want to proceed with it?
Well, it sounds like he wants to go to the grand jury or go to the common police court, so if he waived his preliminary hearing today, that would be the fastest way to do that. And then if he wants to do a bill of information even, Mr. Morford could help him with that.
Do you want to end up in common police court, Mr. Jenkins?
They told me I was going to anyway last week. They said I was going to anyway, so let's just
Well,
go to
but-
file this, send it to grand jury, and be done with it.
So do you want to waive your grand jury, or waive your preliminary hearing, excuse me?
Yeah. Yes, I'd like to play the line, yeah.
And you understand you have a right to preliminary hearing, which the state has to satisfy the judge that you committed these acts. So you want to go to common pleas, is that right?
They said I was, yeah, they said I was going to last week anyway.
They told him last week that if he didn't comply, he would.
Well, I think you were told, I've got two providers here that are telling me that you were told that if you don't comply with treatment, then you'd find yourself in common pleas.
Be bound over to tell them.
All right. I'm sure the judge will grant that for you.
Yes, and he did say on the record he wanted to waive his right to preliminary hearing.
Yes.
So the entire case is bound over to the grand jury. We'll send the waiver down for him to sign. And the bond, I think I set his bond at $10,000 cash assured. That'll be the bond.
He had already been sentenced on one of the misdemeanor cases.
Which one? The fifth?
Could you recite all the case numbers?
Case numbers are CRA 22816, CRB 22817,
Okay, it's the 8/17, Your Honor. He was sentenced on July the 10th, and that was where he was ordered inpatient with RRT.
I don't think that's right, because that was the date he was here. I think that's just a note that they made. There's no entry in the file. That was when he was here last, and he was saying he was going to go to the arrest. I did not sentence him yet, so. Okay, everything is bound over to the grand jury.
Thank you, Your Honor.
Thank you, Your Honor. State of Ohio versus Branson Johnson, case number CRB 21795, and Adam Pingle is on deck.
This is Mr. Steyer's case. Where I had him. There was actually a review.
Okay.
You were the attorney. Looks like you failed to appear for a review hearing.
Okay.
May 20th of 22. It's on a theft offense. It was a Walmart theft offense. He had a review hearing May 20 of 22. You failed to appear, it's alleged. And it looks like you got picked up on a warrant. Do you understand that allegation, Mr. Johnson?
Yeah, I got picked up outside of the street now. Like, I've been in treatment for, at New Life for a minute, and, I just went to court yesterday, and, they ordered me to go back there Tuesday, and I was wondering if we could work out, so I can go back.
Where did you go to court yesterday?
Downtown, over in Ironton. And
Judge Waldo?
Yes. Yes, sir.
Okay. And you're ordered to return to New Life on Tuesday?
Yes, sir.
I've got a letter from the counseling center from July 28th of 2022. It's actually directed to Ironton Municipal Court, saying that you entered treatment at the counseling center June 7th, but decided to leave services against the advice of staff. Because would
Because they tried to put me into a motel they just opened up that I overdosed in for time, and I tried to tell them I want to go back home, because if I go back home, I'm going to be high, and I'm working so hard not to, like, honestly, not to get high. That's my goal, and they want to put me in my own stalking room. And I was just like, I'll go to a different treatment facility, do what I gotta do, like, you know what I mean?
Okay. Well, his entry from this court did not require treatment. It was a standard shoplifting sentence. I was just aware that he was recommended to treatment by, apparently ordered to it by Ironton Municipal. So, all right. How long have you been in jail now?
I've been here, hey, how long have I been here?
It all blends together.
Since 12.
About 2 days, Your Honor.
Where are you living now, sir?
I'm living at what's it called, New Life.
Well, if you weren't at New Life, where would you be?
Across the bridge in Westwood.
Your Kentucky residence?
Yeah, because I'm not going back to Portsmouth. I don't want to go to the life. But if I go back to home, I'm going to end up high, jobless. You know, I mean, I'll be able to see my son. I'm not, like, I really.
Okay, I'm going to send you to time served. You have to comply with Ironton Municipal's orders on getting treatment. And you did do some community service here. You did 3 days of your community service. You still owe 2 days, and you're fine. So
I can do that. I can do that still. My New Life is open.
okay. I'll set a new review hearing for you for August the 14th, so 1 month from today. You got another review hearing. I'll cancel the warrant. Go comply with what Ironton Municipal orders you to do with regard to treatment.
Thank you, Your Honor.
All right. Thank you.
You're welcome.
For that.
Yes, sir.
All right.
State of Ohio versus Adam Pingle, case number CRA 23422 and CRB 23423 A and B. Cornell Rogers is on deck.
And sir, are you Adam Pingle? Can you hear me, Mr. Pingle? Mr. Pingle, you have the right to remain silent. You don't have to say anything. You do, it can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make it safe, prove charges beyond a reasonable doubt. You understand those things?
Yes, sir.
You've got two charges, criminal damaging and criminal mischief. The criminal damaging alleges that on July the 13th in Fayette Township, you caused a substantial risk of harm to the property of Christopher Runyon without his consent. That's a second-degree misdemeanor, maximum penalty is 90 days in jail, $750 fine. Criminal mischief is alleged that you, on July 13th, defaced, damaged, or destroyed property of Wallace Funeral Home. That's a third-degree misdemeanor, maximum penalty is 60 days in jail, $500 fine. Do you understand these charges?
Yes, sir.
How do you wish to plead to them?
Just no contest.
No contest means you're not fighting it and you're agreeing you can be found guilty if I think the state has enough evidence to convict you.
That's fine.
Is that what you want to do?
Yes, sir.
Okay. Let me see if they have a statement. Do you got anything other than the affidavit?
Your Honor, I don't even have the file at this point.
Okay, here's what I've got. Let me read it. An affidavit by Beth Wallace McNearney. Says this person did knowingly cause physical harm to carpeting and flooring of the property of Wallace Funeral Home. Adam Blair placed a running water hose next to two outer doors, letting water run under the door, causing damage to carpeting inside Wallace Funeral Home. And let's see, the other one says Adam Blair Pingle kicked over a large decorative flower pot in front of a Wallace Family Funeral Home, South Point. That was the criminal mischief. Okay, do you have any response to those affidavits? Oh, well, I missed a charge. There's also a felony charge, 23-422. That alleges that on July 13th, you knowingly caused physical harm to property that is owned by the Lawrence County Community Corrections, and that organization is in a profession, business, trade, or occupation. So that makes it a felony 5 vandalism. Okay.
I was hoping to go, I'm not from this area, and I was coming down that way, I was trying to get to OPP, or trying to get back to Riverside, or wherever we are, I was trying to get to, had a drug problem most of my life, and, I don't know, I didn't really remember doing any of that, but when I got arrested, the truth, I'm trying to get a rehab, I'm trying to get away from Huntington.
Okay.
That's
Do you have any money to hire a lawyer?
No.
Mr. Morford, I'm going to appoint you because he has a felony, so I'll withdraw the no contest pleas on the misdemeanors. I can't take a plea on a felony at the first hearing, so I'll appoint you. Sounds like he wants to get, he was trying to be en route to OBP is what it sounds like. He was kind of in the general area when he was at Wallace Funeral Home. So what's the state's position on bond?
What's the address they have for him, Ron?
Homeless?
Staying at the city mission.
Been staying at the Huntington City Mission?
Yeah, at cool weather shelter.
We would not be opposed to an OR bond to go to treatment with electronic monitoring.
And here's the gentleman who may know the answer. Does OVP have any mail beds available? Did you contact them? Or?
Well, Your Honor, just tell you what, they spoke to Mr. James, and they They did their assessment and assessed that he does not need inpatient treatment and that he needs outpatient instead, so we didn't get to that point.
Okay,
Your Honor, I have that
okay.
as well.
Do you have, and you can take him if he, what's your pay source, Mr. Tingle? How do you get medical service? Ohio Care Source? Ohio Care Source?
Yeah, I got care source.
So you can take him. And that's Cardinal?
Yes.
Okay, I've got a home for you, if you want to go there.
All right.
Roof over your head, place to sleep, counseling, food.
All right.
And now it's going to be longer than 30 days.
That's fine. I mean, I don't, is it one where I'm able to work and stuff though, or?
Eventually, I would not initially.
Your Honor, we would like to go ahead and have the preliminary in the more quickly,
Okay.
just because we may decide it has to go to grand jury.
All right. Okay, so what's going to happen, Mr. Pingle? I'm going to let you sign an OR bond to go to Cardinal for treatment, and that'll be in Ironton, right?
Yes.
And
We also have that in Portsmouth if you want him at that location.
It doesn't matter. He's not, where are you from originally, Mr. Pingle?
I'm from Perry County, Ohio.
What's the county seat there?
New Lexington?
New Lexington?
New Lexington.
Okay. So you're going to go to treatment. Now, you may stay in this court, you may go on to common police court. I guess the state wants to look into your background, probably is the main thing. If you have an extensive criminal history, they may take you on to your injury. If not, you may just stay here and go to treatment without getting indicted. Okay, so next, well, I'm assuming you'd waive time to whenever we set it. Is that right?
We'd waive time, Judge. Yes, his treatment is paramount.
Okay, and you want an ankle monitor too, is that right?
That's correct, Your Honor.
Okay. That may or may not happen today. So they want you to have a GPS monitor. And let me just say this. We put that on you, and obviously if you leave, then they know right where to go, come get you to pick you up. So it's hard to do. And if you cut it off, we have had people get the bright idea, well, I'll just cut it off, and then they won't know where to come get me. Well, that guarantees you 3 years in prison if you cut off the ankle.
Right, I understand that.
So let's just set it for a week to make sure we don't lose track of it. July 21st for preliminary hearing. $2,000 OR bond with ankle monitor. We'll have to get adult probation to place the ankle monitor. So you can discuss that with Mr. Major. Start the wheels sometimes don't turn fast on that, particularly on a Friday afternoon, but probably need to start it ASAP.
Am I leaving here today, or?
Possibly. We gotta get an ankle monitor on you, and sometimes that's, I don't even know if they have ankle monitors. And if they have one, can they get it on you by today? If not, then they'll probably do it Monday. I'll put you down for a hearing in a week, just so you're not sitting in the jail and nobody knows what's happening. So the goal is to get you out to treatment as soon as possible, but we got some issues to deal with to make that happen.
It'll be today, or Monday, or next week?
Yeah, that's a fair way to say it.
Okay.
So Worst case scenarios, you're still sitting there next Friday. I don't want that to happen. I don't think that'll happen. But if there's no ankle monitors, then it could happen.
I believe we do have one, Your Honor, just took one off
Okay.
recently.
We think we have an ankle monitor, so that's a good sign. All right. And then, one way or the other, I'll see you next week. So if you go to treatment, you'll come back and they're going to give me a report whether you've been doing what you're supposed to or acting crazy. So give me a good report.
Don't leave treatment.
Oh, I know that.
Okay, any questions, sir?
No, I apologize for the inconvenience.
Well, you got an advantage, you got a chance here to turn things around. Just take advantage of it.
I see.
Okay, that's all.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Cornell Rogers, case number CRV 23205 A and B. Nathaniel James is on deck.
Cornell Rogers is set for pretrial today. He was arraigned on July 7th. He's still in jail.
Judge, I believe we have an agreement for your approval.
Okay.
I believe the state is willing to dismiss the felony or the obstructing in exchange for a plea to the theft charge. Mr. Rogers would take the state up on that offer, Your Honor. He also asked me about common pleas. He has a case in common pleas, appears on the 19th of July, represented by Mr. Davenport. I would imagine, Judge, he's got a hold from common pleas.
Yeah, apparently is why he couldn't get released. So. All right, so he's pleading to which?
The theft.
That's the A case, 205A. And the B case is obstructing official business. That's going to be dismissed. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
All right, and Mr. Rogers, you're agreeable with this? Is that correct? Okay, your microphone's turned off somehow. Probably on your headset, it got turned off. There's a little switch on there that if it gets bumped or something, that goes off. Okay, let's try it again. Can you say something, sir? It's still off. You're not coming through. Let me make sure I don't think I've got you muted.
Can you hear me?
Now I can. There you go. Now you're on the record.
Okay.
So are you, your attorney saying you want to plead guilty to the theft in exchange the state's going to dismiss the obstructing official business? Is that true? You're agreeable with that?
Yes, sir, I am.
Do you have anything you want to say? Okay, and what's the recommended sentence on the theft?
Your Honor, there's no restitution due. He's in jail, so our suggestion would be a jail sentence that we would not oppose if it ran concurrent with whatever else he's serving right now.
Okay.
He waived extradition, Your Honor, I understand, on June 20th.
We had something in common, please, right?
Yes, I don't know what the charge is, Judge, but Mr. Rogers, I checked on your common pleas case, and you're represented there by Mr. Davenport. Your hearing will be next Wednesday, the 19th.
This Wednesday?
Yes,
This
sir.
Wednesday coming up?
Yes, sir.
Okay.
Okay, this was a Walmart theft, so I'll do a $100 fine, court costs, 10 days in jail. I think he's been in that long. I'll give him credit for 10 days served. Yeah, give him credit. And order him to stay out of Walmart. Review hearing January the 12th of 24.
Excuse me, sir?
You got a review hearing just to pay your court costs. I'm not even going to do community service on this. But you either have to pay your court costs by January 12th or show up for a hearing that day at 9 a.m. to explain why you can't pay it.
Yes, sir.
January
Who do I
12th.
pay? Who do I pay?
You can pay it online. Go to the court's website. You can pay online.
Look up Lawrence County Municipal Court, Mr. Rogers.
All right, Mr. Porter, thank you.
Yes, sir. Good luck Wednesday.
All right, thank you, Judge Gaffney.
You're welcome.
Thank you, Judge.
State of Ohio recalls Nathaniel James to Lawrence County Jail, case number CRB 23317.
Your Honor, I spoke to OVP. They called down there, did an assessment. They assessed that he does not need inpatient, that he is a candidate for outpatient services, but not inpatient. So I don't know where that leaves us.
What's the state's position? He's been in jail for a while now.
Yes.
Yeah, that's.
A week or more, probably more.
I got a missing four-wheelers, I got a missing lawnmower, weed eater, taking my stuff all in jail. Where I was evicted or whatever, I had all that stuff outside waiting to go, move,
Your Honor,
and we got it.
Your Honor, if we could possibly do outpatient and then allow him to come back soon.
I can be here next week, I can set it all up and be here next Friday, you know. I'll set it up, get it going, outpatient, take the drug screen, if you want.
Where are you going to be living when you're out of jail?
I'll be living with the mother of my children there in Proctorville.
Okay. Well, I'll refer you to OVP. There's an OVP in Proctorville. Do you know where it is? Outpatient.
No, where's that exactly?
Well, you know where the Kroger is, right?
Yeah.
Right next door to Kroger.
Oh, really? Okay. Perfect.
We're in the next building that's got the hardware store in it. There's a OVP building in that same plaza.
Oh, what, the A hardware thing?
Yes.
Okay, great, that's perfect.
So I'll set your next hearing for July 21st. And set it as a pretrial and expect to have a report that you've been there then.
Okay, great.
And I'll change his bond to 1,500 OR bond.
Okay.
Thank you, Your Honor. Mr. James, you got that date, the 21st at 10 o'clock.
Yeah, that's next week.
Yep.
Right,
Next Friday.
Yeah, I'm being released though, right?
Yes. As far as I'm concerned, unless another court has a hold on it.
State of Ohio recalls Austin Carmen to Lawrence County Jail, case number CRB 21697, CRB 2897.
Yes. I didn't get that. All right, Mr. Carmen, I got in touch with your lawyer. He can't be here today. And he doesn't, I thought he had another case, but he actually doesn't. This is the only thing he would have, and he didn't know that you were going to get arrested on a warrant, so he didn't know to be here. So what I'm going to do, I'm going to set a bond for you. Is there a bond you think you can post? I haven't set it yet. Have you got some money that you can pay a bail bondsman? Okay, I'll set it at $2,000, cash or surety. That's up to the bail bondsman, but that's usually what it is. So you want to talk to the bail bondsman. Now, Mr. Sowers was going out, he's interested in criminal mischief. Oh, okay.
I didn't know that, the last time I talked to my lawyer, I knew that this was the case. And, he told me that he would hear back on it, so so he sent me back to the house and said he would contact me, and he never contacted me, and they said, you know, I had a warrant for my arrest, and you know, I was out riding my bike, and the cops seen me, and he said, Mr. Barnes, you know, you got a warrant, I did, so.
Okay. I'll set, you're confident you can post the bond?
I'm not too confident, but.
Oh, well, I'll set it sooner then rather than later. I'll set it for July 24th. July 24th will be your next hearing.
I can for sure make bond, I have the money, I just have to take it from my friends, but I can't make it.
Okay, we'll have a bail bondsman contact you. You need to be in court on July 24th at 10 o'clock. That's a week, not this coming Monday, but a week from Monday. You're welcome. And that finishes our cases at the jail.
State of Ohio recalls Jared Brogdon, case number CRA 21-597, CRB 21-598, and TRC 21-2826, AB and C.
That's Mr. Steyer's case.
Your Honor, I spoke to Mr. Rognan. I think some of the issues in that report are reflective of the fact that when he came to Southern Hope, there was a delay in getting him his psychiatric medications, and he has gotten those since then, and he is in his progress and mental state, attitude have improved, and we were actually kind of surprised to see the negativity in that report. I didn't ask your name, I'm sorry.
David Hunt.
Mr. Hunt is here from Southern Hope, and he also expressed a little bit of surprise about the nature of that report. He said Mr. Brogdon's doing well there, and also he confirmed the issue with the psychiatric medication and had said that as Mr. Brogdon's gotten onto the medication, that has helped him going forward. And we recognize the issue with his non-appearance. However, as we look at this, I think we do need to take into account that there's some value in the fact that he came back on his own. He didn't wait to get dragged in here in an orange jumpsuit or show up on the TV. He came in here and said, hey, I missed court, I need to get back onto the docket. I do have the old case. Like I said, it's an older case. I have discovery. I haven't really refamiliarized myself with it enough to know what the evidence is and what's there. So at this point, what I'd like to suggest and request from the court and to Mr. Hill is that we set this out a little bit of time and ask Mr. Rognan to really take that time to prove himself, to prove that, what happened there is something he's trying to fix. He's in an inpatient program at this point. He's making good progress while he's there. And set this down the line, and if he doesn't prove himself, then obviously we've got a lot of options here, but give him that opportunity.
Mr. Hill.
We're not opposed to some time, and particularly because I believe that Mr. Steyer should have some time to refamiliarize himself with the OVI and the domestic violence charges. And we understand the need to do that, but if two things don't happen next time, then we're just going to take the domestic violence and the interference with, or whatever that charge is called, the disrupting to the grand jury. So we would be wanting a plea to the OVI and a plea to the domestic violence next time, and our recommendation would be a large suspended sentence and continue with his treatment if he wants to do that next time. Otherwise, we'll take it to the grand jury and we'll leave the OVI here and we'll fight that out here. But we would also want a time waiver for that as well.
We'll execute a time waiver today as
and
well.
We would also want Mr. Ragnan to show some real improvement as far as his next report from Southern Hope in order to keep the case here also.
And I would defer to the court on what sort of a time frame is appropriate. I think you stated that you're pushing into August at this point. I remain available basically any court date other than the 18th and 21st, on which I have common police trials.
Well, let's do 28th, 2 weeks. Give him 2 weeks to prove himself. We need a glowing report next time.
Thank you, sir.
July 28th, be the next hearing for Mr. Rodman. 10 o'clock. Pre-trial and preliminary.
Thank you.
Stick around a minute until I'll talk to you. Come for your glasses.
Thank you, sir.
State of Ohio versus Kyle L. Akers, case number TRC 222527, A and B.
Mr. Stratton's case, pre-trial.
He might have shown up.
Same person.
Oh. Okay, this is one that Mr. Sowers is trying to locate. I think, is he the one that was in Kentucky? Or he said he moved it, I can't remember.
Yeah, he said he moved and he's trying to locate him.
Yeah, this was put on the docket. I didn't know it was on the docket today. I'm not sure why it's on the docket. I thought there was a warrant already issued in this case.
I think there was on a CRA 23378, so this is an OBI. Apparently there's a felony also.
Oh, okay. Oh.
Yeah, see, 23378, that was issued on June 3rd. This was set for a pre-trial today, so obviously he's not here on this either. So this actually had, I think, an OR bond on it, so.
Yes.
I'll just issue an order, or for a warrant on this also, but it's on a OR bond.
Yes, John.
State of Ohio versus Michael B. Anderson, case number CRB 23394.
Senate 28.
I didn't know there was a domestic in here. Portia Anderson.
What we would like to do is subpoena her, come back in a couple, 3 weeks.
Okay. Okay. Yeah, he'll put it on Friday.
So they have no contact with her, so we'll try to subpoena her.
This is probably going to be a 90-day thing, just dismiss it. Okay. Here, CPS. Your Honor, we just need to reset this in a couple of weeks. The alleged victim in the case is not here. I guess the state wants to subpoena her, so.
You have good contact information?
Well, we have contact information, so we'll keep trying. We have left phone messages for her, and she hasn't responded.
And how long before you come back?
2 to 3 weeks, Your Honor. Not on the 31st. I have a trial that day. If we could do it on a Friday also because of his work schedule.
Let's do the 28th, July 28th.
Okay. You want to come in?
Appreciate it.
State of Ohio versus Ethan R. Anderson, case number CRB 2319.
Your Honor, may we approach?
Yes, Ethan Anderson, pre-trial.
So he had a felony case that was just recently dismissed. So I just asked this.
Is he still at Minute Reads or? No.
He was permitted to leave Mended Reeds and go to hometown, and that's where he is now.
So he's still there? Okay. Is he under QRT?
Yes.
Okay.
So I just asked this for you to say, Your Honor.
Yeah, that's fine.
August 7th?
Yes, that's fine.
I'm preparing a time waiver, Your Honor.
Thank you.
Yeah, we'll waive time.
This is a copy of that.
State of Ohio versus Christopher J. Blevins, case number CRB 2286, CRB 19439 A and B, TRC 21595 A and B, CRA 21162.
Okay, but. Let's get this.
Say you nailed it with the assessment, with his barriers and attitude.
You're still working.
He has a OVI that he's previously pled to and
I think is it a DV?
theft, and then he's got a pending domestic,
Yeah.
and the whole goal has been to get him in long-term recovery and take it seriously, which he has been in recovery before, and he's also fell out, and when he falls out, he falls off hard.
Well, it's not always a straight trajectory there, Your Honor. It's kind of 2 steps forward, 3 steps back, but.
Well, I think the main barrier, right, is that he's not really on board with everything.
Yeah.
I think he goes through the motions to avoid some negative consequences, which I'm kind of okay, but I'm waiting for the light to come on. It's like, I need to adopt this and make it my lifestyle, but I'm cut out some of this stuff, and cut out some of the people that lead me down that path. I don't know if that's going to happen or not, but I mean, we got this case. We need to, at some point, do something with it. It's been pending for quite a while. It's got, you know, he's got this OBI from 21595 is the case number. He hasn't done anything on it.
I did the community service,
Well, unless you had some community service from all cases and went there first, but there's not showing any community service on this one from November of 21.
I just started working at Chick-fil-A. I've been working almost 50 hours a week. I get paid Tuesday. I could pay on them. It's my first paycheck. They held out my first 2 weeks, and I didn't pay me for a day.
Yeah. Was he sentenced on the OVI, Your Honor?
Yes, yes.
Did he get jail time? I guess he got some.
Oh,
jail time.
suspended, yeah. 60 days, suspend them.
And is this treatment an order out of that case as well?
All cases.
He had treatment ordered on a drug paraphernalia charge that he pled to at the same time.
I guess, Your Honor, is what the state wants to do with the domestic violence, because that's the outstanding case. We've been pending for a while on that and coming back on the sentencing. In Mr. Blevins' defense, I just like to mention that sometimes, you know, when he gets out there, he'll get a place, start doing very well, getting a job, making some money, and then he'll make a bad decision and fall off the wagon. And that's happened again and again, but he gets right back up on the wagon. And whenever he does fall off the wagon and he goes back to treatment, he sort of loses everything that he's sort of built up. I think he's lost his apartment and lost a job, and that's where some of the, I guess, negativity is coming from, is because he thinks he's making progress, and then he ends up losing everything that he's built up so far. So I don't know if that helps in the court's assessment of where he's at and where he's going, but I just want the court to know that.
Well, I take the Regal Recovery Care's assessment of his current situation at face value, and it doesn't sound good. I guess our suggestion would be that perhaps applying the leverage over the situation that is the 60 days in jail that have previously been suspended, maybe imposing that and then allowing Mr. Blevins to come back in a few days and maybe state a different attitude about going forward. That would be our suggestion.
Your Honor, he now has another job. I hate to see him lose another job because of some of these issues.
Is he inpatient with you?
Yes.
Okay.
So, I think really should work as a patient. Your Honor, I'll leave it up to the court, but.
Well, can we even get some sort of promise from him that he'll do better?
Yeah, I'm on track. I'm on track.
Well-
What's been happening is,
Let me read some of what this says. I don't want to throw a wedge in there, but I think it's pretty honest and accurate. Negative behaviors, yes. Dishonesty, indifference to his situation, not taking recovery seriously, acts as if it's a joke. Now, on the positive side, it says you have a good work ethic. So, I think you're kind of like a chameleon. You can blend into whatever, if you're in with a group of partiers, you're going to fit right in with them. And you can go into a treatment facility and probably know somewhat what to say, but it may not be that genuine. You got to make this. You got to make this your own. Otherwise, I mean, just with your behaviors that I've seen before, you're going to be at risk.
I'll do better.
We do agree, Your Honor, when he falls off the wagon, he falls off hard.
Let's do August 11th. I don't even want to go a month, so let's go a little closer. But you do have jail time over your head, so if you need some negative reinforcement, there it is. On your prior cases, that you haven't done anything on.
Pay some money on them.
You got community service, you got fines to pay, you're ordered to go to the driver intervention program. You haven't done anything. But I'm more concerned about you getting clean. So, I wouldn't be harping on those things if I felt like you were really in there making a great effort and changing things. And we weren't going to see you back here repeatedly over the next 6 years that I'm going to be here. So that's what I want to see. Convince me that you've changed, and we're not going to see you here, not because you just moved away, but because you've changed your lifestyle.
I'm tired of losing everything.
Yeah, whatever the motivation you need, adopt it. It has to come from within you. It can't come from all of us who want it for you. And I think, was this a family member on the domestic?
Yes.
I was acting crazy.
Yeah, I'm sure they want it too, but you gotta want it. Okay, we'll see you August the 11th.
All right, thank
you.
Better report.
Sean. Yeah, I'm going to take this copy. Copies at the office.
State of Ohio versus Kyle Davidson, case number TRC 23764, A, B, and C. Kyle Davidson.
Yeah, Kyle's here.
Your Honor, I received the video in this case, and I have not had the opportunity to sit down and review it. It's a 6-hour video, so I just need another pretrial on this matter to review that video.
Okay. Be in August when do you want to come back in August?
Middle of August be okay.
August 18th.
There you go. He just asked for that date, too.
Okay, very good.
All right, man.
August 18th will be the next hearing.
Thank you, appreciate it.
10 o'clock.
State of Ohio versus Lance M. Davis, case number CRB 2350 A and B, PRC 2339 A, B, C, and D.
Mr. Strax.
Your Honor, we'll set this one for trial.
Well, August 4th is out, because there's several already set, but after that, pretty open. Anytime the 7th or after of August, so
August 7th is fine.
7th at noon.
At noon.
Noon for trial on the 7th.
All right, thank you.
State of Ohio versus Kenneth Roberts, case number CRB 23142. Kenneth Roberts.
Mr. Strax's case set for pre-trial.
I have not heard from Mr. Roberts. Good.
What's your name, sir?
Sean.
So is this issue. He's not here, Your Honor, so if you just want. Give us 7 days. Roberts.
Kenneth Roberts.
Yeah. The bench warrant issued for failure to appear.
Yes, sir.
State of Ohio versus Bradley Thacker, case number CRB 23330.
Strax's case.
I think we're just gonna have to either have a trial or if he pleads, we can argue sentencing if you want to. To sit it, to use it, to try to, yeah, that's not what my information is. Is that what we're almost thinking? It sounds like we have permission to sit in it.
Your Honor, we'll just ask this be set for trial.
August 11th?
Yes.
August 11th at noon.
August 11th. Okay.
Your Honor, Walter Patrick has reported for jail as ordered today. There is a current jury description.
Acceptable. His next hearing is September 21st for review. That's marked.
State of Ohio versus Damian Fox, case number CRB 23307 A and B. Damian Fox.
May I approach, Your Honor?
Yes.
Apologize, Your Honor, hear you. Right up the microphone.
Let's see. Mr. Warford had been Mr. Fox's attorney.
Yes, sir.
Your Honor, Mr. Fox is also being monitored by Justin Preston through parole.
Your Honor, I advised this morning by Taylor that they were discharging from the program license and back.
Okay.
That just belongs to the dock today.
Yes. The incident this morning. The incident this morning.
Anyway, I go to a video, sir, like the argument, somebody called me out my name, and I just pressed back one time. Like, I really didn't get in the program. I can do another, she told me, and everything.
Have you seen the report, Mr. Beal?
I have not.
Have you, Mr.? Why don't we let you talk with Mr. Fox and go over the report, and we'll recall it. Give you it back in the holding cell.
Thank you,
Thank
Judge.
you, Your Honor.
I want you to stay, we got two of your cases to dispose of before you go back. Yeah.
State of Ohio versus Charles Hutchison, case number CRB 21584, TRC 192635 A and B, TRC 181210 A and B, and TRC 181210.
I have not seen Mr. Hutchinson, Your Honor.
Nancy Hutchinson.
All right, he's not here, so it'll be a warrant.
State of Ohio versus William K. Elkins Jr., or the third, case number CRB 23347.
This is Mr. Warford's case set for pre-trial.
How you doing? Sir. Yes, sir. For the court, sir. It's the same paper, just a copy of it.
Judge, may I approach?
Yes.
Report from Pat.
Okay. report.
If you'll recall, the first time he was scheduled to be here in court, I requested a continuance because his house burnt to the ground. He has now found a place to live, at least temporarily.
He's going to continue a path.
Yes, sir.
What's the state's position?
We are encouraged that he's started his treatment in a good way, so we want him to continue to do that if they're willing to waive time.
We're willing to waive time, Your Honor.
August 14, next hearing. Continue with your sessions at that.
Thank you, sir. Good luck.
State of Ohio versus Trevor Dement, case number CRA 23380, CRA 21167, CRA 2630, CRA 2321, CRA 2322.
Cassandra Carter.
I paid last week, or last week. I might be able to pay Monday. I'm supposed to get some more money.
Is this a copy to keep?
Do you need that back?
Yeah, no, you can
have that for the file, Your Honor.
Okay. It's a good report.
Your Honor, we have here today the alleged felony domestic violence, as well as a number of old cases that are on review or pretrial on review. We have a good report from treatment. It's my understanding that the victim in these matters does not wish to go forward with the charges. She's already asked not to have a protective order. Mr. Dement is interested in continuing on with treatment. That's doing him some good, and he intends to continue on with that. I think Mr. Heald's intention is to take this on to the grand jury at this point. If that's remains his preference, we would ask to go ahead and waive our right to preliminary hearing to secure his bond. But if Mr. Heald's willing to keep the case here, we'd be willing to continue to waive time constraints to keep it here and deal with continue treatment and deal with the older cases.
And that is what I expressed to Mr. Steyer earlier today. I understand also that the victim requested that there be no protection order previously, and that sometimes is indicative of their overall feeling about their willingness to participate. That's on one side of the ledger. On the other side is the fact that we've had Mr. Dement here before, I believe, and it seems like for a long time. We want him to succeed, and it's encouraging to get a report like that. I think that at this point, we would kind of like to go down the middle and offer him the opportunity to be in treatment here if they'll waive time, and allow us some time to make sure about the circumstances of the case and the victim, as far as exactly what we need to do, whether we need to go forward or not. I will say this, that if we were to keep the case here, this would not be an outright dismissal kind of a case. And it may be that we'll offer some compromise in the form of a misdemeanor, but it's going to require Mr. Dement to really get it done this time as far as his treatment. So we'd like a continuance to make that decision.
And we are certainly willing to waive time constraints to accomplish that, Your Honor.
But he's an inpatient now at OVP. But he'll be finishing up there probably.
Yeah, in a couple weeks.
Yeah.
Probably almost 3, I think I got left. 2.5 or so.
So you definitely want to come back before then, for that. Maybe
We said something on the 28th.
about the 24th.
Let me look at my
Finish
calendar.
Before the 28th.
Oh, okay, I
I think
misunderstood.
that's around the date I'm supposed to.
I'm here the 24th.
Okay, let's make it July 24th.
Keep up the good work. Wait till they say we're done.
Yeah, she needs to turn that back on sound.
Yeah.
All right, you're pretty good.
Thank you, Your Honor.
Thank you.
City of Ohio versus Kara Hearn, case number CRB 2381.
Mr. Stratton's case.
Your Honor, Kara is back in inpatient at Bethesda.
Okay, I agree with the report. I mean, I think she's where she needs to be now.
I do too. I knew it was too early whenever I left.
I'm sorry, I didn't.
I knew it was too early when I left before.
Okay. Well, you were getting pulled in different directions, I understand that, but you know, this has got to be the top priority.
Yeah, I know.
Okay. So, let's make it work this time. And, you know, you've got a lot of people pulling for you, hoping that you do well, and you are capable of doing this, so. Is there anything that I can do to make things easier for you?
No, it's just things I've got to take care of myself.
How about child care? What's going on with your son?
He's with his dad.
You feel confident in that he can take care of adequately?
Yeah, he'll take care of him. And, you know, it's just a couple of weeks before I'll be able to call him, so that was the only thing I was concerned about. I'd like to at least talk to him, but.
We can make arrangements for the child.
Okay.
Yeah.
Anything else that, and QRT's gonna stay involved with her? Or?
Yes, that was my question, since she's back in outpatient, if you want me to continue to meet with her once a week?
She's an inpatient.
Inpatient.
Yeah.
I'm sorry, I meant to say inpatient.
Yeah. I think it's good if, I mean, you've formed a relationship. I think that's, because eventually, I think the big issue for her is when she leaves inpatient. That's when we need, she needs the support, and I think having a relationship is so important.
And Your Honor, we did have one more concern. We have had a concern come up that she might be interested or wanting to ask about switching facilities again.
But that was just because of the phone situation, the contact with my little boy.
But we'll make arrangements for the child.
Okay.
We just wanted her to stay where QRT wanted her to stay where she's at.
I'd rather
All right,
stay where
I agree
I'm
with
at
that. I
too.
think that's best.
Yes, Your Honor.
Okay, let's, maybe 2 weeks?
Yes.
Come back in 2 weeks? Now, that's the 28th. Are you available?
Yeah, the 28th I am, the 31st not.
All right. July 28th will be your next hearing, Mr. Ernie. I think you're in the right place and making the right decision.
Thank you.
State of Ohio versus Trevor Fitzpatrick, case number CRB 23-232, A and B. And TRC 23-379, A and B.
It's Mr. Smith's case. I'll keep it.
He's compliant with treatment right now, Your Honor. He's also, I think he's completed 12 hours community service, which will be probably, I assume, since he pled to 2 first offense OVIs. This is one where he's going to OVP. He's got a job now, is that correct?
Where's work?
I'm working at a Fuji in Ashland right now.
What's the name of it?
Fuji, the steakhouse.
Okay.
Steakhouse.
Yeah.
He's working and
I can go out of town to my other job.
so he's working towards trying to get stuff completed, and I'll obviously finish with his treatment. So we'd ask just to keep on monitoring his treatment.
Okay, so I noticed they give reports, but they haven't said he doesn't need any more. That hasn't been said, so.
No, it's just that he's maintaining compliance. So I assume that at some point he'll get a certificate of completion. So we're working towards that goal.
Mr. Heald?
We're not opposed to delaying the sentencing further.
Okay. Well, you've got 2 OVIs. That's pretty serious stuff. So, I said this before with other people. I want to make sure, convince me that you're not going to have this as an issue anymore. That's what I want to see. And you're out running around. You notice when you sit here in court and see when people get OVIs, Mother used to say, nothing good happens after midnight. You're out at 4:18 one time, and the other time was 1 something. So when you got a job, usually those are hard times to get out and mess around, because you got to get up and go to work. But I'm assuming you're wanting some leniency and not to go to jail. So I want to be convinced that I'm never going to see you again on anything like this ever again before I let you go.
Yes, sir.
Because if I don't, you go get hurt or hurt somebody else, and they're going to come back and say, this is his 3rd time. He had 2 just within days of each other, Judge, and you didn't do much to him. That's going to be on me. So convince me that ain't going to happen. Right?
Yes, sir.
Okay. August 14th. It's your next hearing. Is that a good date for you, Mr. Smith?
Yes, sir.
Okay.
Thank you.
State of Ohio versus Ronald Ferguson, case number TRC 23-923, 8 million suits. Ronald Ferguson. Ronald Ferguson.
All Ronald Ferguson?
Yes, sir.
Come up to the table to your right, sir.
Yes, sir.
Mr. Ferguson is alleged on July the 8th at 10:03 p.m. in Rome Township that you were operating a vehicle while you were under the influence of alcohol or drugs. And it's alleged that you had a prior, but it was in 2011, so that's beyond the look-back period. So this would be considered a first offense. On a first offense, the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. The minimum penalty is 3 days in treatment, $375 fine, 6-month license suspension. You're also charged with having a license that had been suspended that you never reinstated. So that's driving under an unreinstated license. That's what's called an unclassified misdemeanor. Maximum penalty is 500 hours of community service, $1,000 fine. There's no jail time on it, but you can get a bunch of community service. You're also charged with reckless operation. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand these charges?
I do.
Do you understand your rights?
Yes.
How do you wish to plead?
Not guilty to the driving under the influence. The other two, yes, but driving under the influence, my vehicle wasn't even in my driveway. It was nowhere near me whenever the officer gave me the sobriety test. It was actually parked in the school parking lot. There have been threats. I've had sheriff to my house probably 6 times in the last week and a half. But for bodily threats on my family, neighbors told us they were going to murder us and drive us underneath the trailer. They chased us out the night before this all happened, literally down the street. A group of them chased us down the street with my son in the backseat of the car, saying they were going to murder me if I stopped the car. And when I took off the other day, they were trying to block me, and they were putting cars end to end at the end of my driveway, telling me that if I tried to leave, they were going to murder me. So that's why I got in the car and drove to begin with. But I was not under the influence of alcohol. I came back home 2 hours, maybe 2 hours before the cop showed up, and I had a few beers before the cop got there. He came outside, gave me a sobriety test, and wrote me down for a DUI. But I wasn't behind the wheel while I was drinking, period, at any point.
I'll take that as a not guilty plea.
Yes, not guilty.
Do you wish to be considered for a court-appointed lawyer?
Sure.
Do you have a job?
No, not right now.
You have no income?
No.
Mr. Morford, I'll appoint you. Okay, since he has appeared today, you can sign a $1,000 signature bond.
Thank you, sir.
Not guilty plea is entered.
Need to sign right here.
Let's look at anything August 7th or after.
There's also multiple reports that have been filed with the sheriff's department. I got the medical reports as well.
Mr. Moore.
Oh, I'm sorry.
Judge, I'm pretty good in August.
August 7th will be the next hearing. Be a pretrial at 10 o'clock.
Okay.
Not guilty plea is entered. Speak with Mr. Morford. You're free to go.
Thank you, sir.
Be back here August 7th, 10 a.m.
Appreciate your time.
State of Ohio recalls Damian Fox, case number CRV 23307 A and B.
Your Honor, I spoke with Mary Nagle at the Cardinal, who's willing to take him.
Okay. Thanks, sir. All right. Is she still here? Or?
She's getting lunch and she'll be back.
Okay. All right, so Bethesda wants Mr. Fox discharged from their services. You say Cardinal is going to take him?
Yes.
Are you, it's been represented before that Cardinal would be going to take Damian Fox
Yes.
today? You take him
Yes.
today? From here, or how are we going to do that?
I can take him from here, or I can pick him up from the jail, however you want to do it.
Well, it'd be easy.
Which house you taking to? One in Ironton? If Yeah, well, I have vets in both places, so, if you want him in Ironton, he'll go to Ironton.
I'm having it packed up at the office. I can give her the address and you can stop and get it if you'd like, or we can deliver it, however.
Okay, this is the last chance. Okay, Mr. Fox, you're not in charge of the facility. You can't boss around the staff. You can't boss around the other people that are getting treatment there. You can't threaten to fight people. You can't be obstinate. You can't not go to groups and not participate and act like you're totally uninterested. Otherwise, just go back to jail and sit in jail.
Yes, sir. I apologize.
You're the one that says you need treatment. You admit you need treatment.
I do, my medication was really messing with me, and I'm not getting adapted to it. And like the other day, today this happened this morning, somebody cussed me and I cussed back, but they found cocaine on a kid and they didn't discharge him. This just happened. And they discharged me for a cuss word.
It wasn't cocaine, it was Wellbutrin. It was tested. He's
No, I'm not
actually,
saying on me, I'm talking about the cocaine they found in the facility.
it wasn't cocaine, it was Wellbutrin.
And the box.
It wasn't cocaine, it was Wellbutrin.
Yes, sir.
And the whole house has been locked down.
I'm sorry.
And I do have video of him initiating the fight.
He called me on my name first, man. I'm
Okay.
sorry.
Okay, we're gonna try this, come back, he's already on the docket for the 28th, so let's keep that date. He's going to Cardinal, last chance.
So thank you, sir. Thank you, Gordon.
Yes.
Thank you, Your Honor.
Thank you, Judge.